Hello, everyone. This is Mo from Mo in the Deep End, and we are starting the defense case for the Boy in the Box trial. I know that we have a verdict and everything, but we are still going to try to see how the defense, kind of structured their trial and tried to get the things going. I am not quite sure what they picked. I know that we were not impressed with Cousin Lemmy. I know he has a real name, but I do know that we were just not very impressed. I will put it up to 1.25, and hopefully we will kind of see maybe where there were maybe some holes in the defense or what they chose to look at. I am not quite sure. I am picking up where we left off at the end of All the Ring video. So let's hope that we are at the right place because this is where I believe we left off. I had the timestamp on there. So hopefully we are at the generally right place. I do have the, uh, yeah, I know. Yeah. And I do have the sentencing on my, big book of, all the things plans that we have. I do not know where Frybert went. So that is oh, there you are. He's just out of camera range. So I have not put him up yet.
So you're done now, right?
Yeah, no, guys, sorry. Bless.
Okay, how much do you have of that?
I have 2 vocabularies.
Okay, I'm gonna come in and grab that in a couple minutes and have you get some of those shells.
Okay.
Good morning, Paige and Reindeer and Lucy and Aces, Wildflowers and Crime Spy.
Okay. Alright, why don't you leave the stuff in here? I'm gonna have you your shoes. No, your shoes right there.
Oh, yeah, I need to check my shoes. I brought this one.
Can you tuck it in?
No, it's not gonna be good.
Okay. So
This is Megaton's room. Megaton. Yeah.
Well, we'll not do bucket. Okay.
Maybe later you can see my class. Yeah, I'm very soon.
All right, thank you. Does the state have any additional items to publish?
We don't, Your Honor. At this time, the state would rest its case.
Okay, ladies and gentlemen, that concludes the state's portion of the case. The state has rested. There are some things that the court needs to address outside of the presence of the jury. So, Mark, if you could escort the jurors into the jury room, and I'll let you know when we're ready for you.
Oh, they coordinated. They're both wearing blue. I didn't notice that actual day.
All right, everyone may be seated. Does the defense have any motions?
Judge, at this time, we're going to move for our first judgment of acquittal. Essentially, obviously there's 3 counts here. The aggravated child abuse count has 5 different ways that it can be proven by the state. Either aggravated battery, willful.
So I really think that the Ring doorbell definitely did not shine parents in the best light. And I think the fact that he didn't get on the stand to mitigate the fact that he sounded like, look, when you are trying to talk to your child, a child who is making adult decisions, bad adult decisions, who is acting out, who is making adult choices, who is not behaving, you may use language, you may use a tone that is not right. They've also, again, I mean, they locked him up in a room. They did not go to a house. And, you know, my guess is the oldest sister's testimony. My guess is, you know, again, all they had really to go on was the older sister's testimony. I don't think that the son's testimonies did the state any favor, but I think that the Ring video where the dad was yelling and kind of being sarcastic and a bit of an ass, that's all they really had. And, you know, regardless of how we all saw it, I mean, if that's all you had, then I can see very much how they could have ruled this way. And they didn't get to know all of the stuff that we had outside of the trial. We know a lot more about what the son was engaged in versus what they know, because they weren't allowed to know about the son's prior bad acts and things like that. So I think that's definitely a lot of the factors in it.
Full torture, maliciously punished, willfully or unlawfully caged, finally knowingly, willfully committed child abuse, and in doing so caused great bodily harm, disfigurement, or permanent disfigurement. The state in this case, I think, has failed to prove that Mr. Ferreter willfully, intentionally inflicted any physical, mental injury that resulted in great bodily harm. The terms great bodily harm, permanent disfigurement, these come from the aggravated battery statute. There has been, as far as I can recall, no testimony that the child suffered great bodily harm, which means distinguished from slight, trivial, minor, moderate harm, and as such does not include mere bruises, which were also not presented. Likewise, there's no testimony that this child was in any way disfigured. Aggravated child abuse is committed through other ways as well, of course. Malicious punishment is reserved for certain types of cases. In Florida, Wheeler v. State controls in this district. It's 203 Southern 3rd 1007. In that case, the rule that comes from that case is that great bodily harm or permanent disabilities or disfigurements are what demonstrate actual malice on the part of a parent and not merely a momentary anger or frustration. So the state, I think, has failed to prove actual malice. Malicious, there's a definition for malicious in the jury instructions. Wrongfully, intentionally, without legal justification or excuse. Maliciousness can be established through circumstances, and one could conclude that a reasonable parent could have engaged or not engaged in that conduct, depending on those circumstances. I think
in a motion for JOA at this stage, doesn't the state get the benefit of all favorable inferences? And so if I were to buy your argument there, at this stage, I would have to conclude that they have established malice.
Well, I do think that I think actual malice, though, under Wheeler, is that it's not any sort of a momentary anger or frustration. It's discipline that results in great bodily or permanent disabilities and or disfigurements, or demonstrates that the actual malice on the part of the parent was not momentary anger or frustration. So I don't know that we have any evidence of that. I haven't seen any evidence of that. What the state is essentially relying upon factually from that perspective is moments where he comes in, he's yelling at, and those interactions that we saw this afternoon on the video, those fit more frustration and anger, if anything, but not great bodily harm.
But we're talking about malice and we're talking about intent, right? I mean, that's the purpose that you're making this argument at this stage, right?
No, well, I'm going under the 5 ways to prove child abuse. Of them, I'm going through them. So I'm saying it's not aggravated battery. I'm saying it's not malicious because we don't have great bodily harm. I also believe it's not torturous. I don't think there's any facts to go to torturous. And I think that the closest call here would be for the state is caged.
So you're trying to convince the court at this point that no jury could ever find that being confined in a 8x8 room or box, however you want to refer to it, that no jury on earth could find that to be torturous? Because I really have to find that no reasonable jury could conclude that that was torturous under the facts that have been presented. Again, which is why at this stage, the state gets the benefit of all favorable inferences. Is that the leap you're asking the court to make at this point?
So torture involves extreme or sadistic conduct, which is absent here.
Well, I'm going to push back on that. I don't know that it's absent. What I believe is that there's certainly enough for a jury to determine whether it's torturous, evil, or sadistic. I mean, the video displayed many repetitive instances of the father coming into the room, his son snapping to attention in demonstrable fear, a repetitive, consistent berating of the child. It seems to me, and I'm not judging the facts one way or the other, I'm just merely determining whether they meet the standard at this point so that they can be passed along to the jury to make that determination. And it seems to me that a jury could conclude that this is torturous and it is something done with evil intent and malice. So move on from that, because you're not going to convince me that no reasonable jury could conclude that this is a torturous event here in the life of this child.
Well, in terms of the other elements, you have the argument was malicious, and in that I want to also draw the court's attention to Wheeler, which I gave the court the cite, but there is a clear difference between a parent's discipline and something that goes beyond and results in great bodily harm to the child. So I don't believe we have that here.
Okay, so let me read to you a provision that comes out of the case of Slocum versus State. That's at 757 Southern 2nd, 1246. And I'm quoting from that case because I think the part that I'm going to read is apropos to this. And just bear with me for just a second, Mr. Wade, while I get to it. The court said, and this is out of the 4th District Court of Appeal, which is the court that obviously handles direct appeals from this circuit, regarding another conduct element of aggravated child abuse. The dividing line between permissible punishment and malicious punishment is not always easy to draw.
I do really like this judge. He really does think everything through.
A defendant maliciously punishes a child if the punishment is imposed wrongfully, intentionally, without legal justification or excuse. The element of malice requires evidence that the defendant acted with ill will, hatred, spite, or an evil intent. And then the court cites the Gaylor decision where that court made this statement: the determination that a parent or one standing in the position of a parent has overstepped the bounds of permissible conduct in the discipline of a child presupposes either that the punishment was motivated by malice and not by an educational purpose, and that is, was inflicted upon frivolous pretenses, that it was excessive, cruel, or merciless, or that it has resulted in great bodily harm, permanent disability, or permanent disfigurement. And I think that recognizes that the great bodily harm, permanent disability, or permanent disfigurement is only one aspect of how you get to ultimately a conviction in an aggravated child abuse case. But the point I want to make here, and then I'm going to switch to one other case, and I'll let you have the floor back. And this is the Tate versus State decision. And I'll give you that site. That's at 136 Southern 3rd, 624. And this is what the court said in Tate, which gives me great pause in terms of the motion for judgment of acquittal here. And it says, Tate suggests that the state failed to prove that Tate intentionally abused HR, which is similar to what's being argued here. Because direct evidence of intent is rare, and intent is usually proven through inference, a trial court should rarely, if ever, grant a motion for judgment of acquittal on the issue of intent. And they cite a number of cases holding that intent is rarely susceptible of direct proof and is almost always shown solely by circumstantial evidence. And this picks up with what you said. Where reasonable persons may differ as to the existence of facts tending to prove ultimate facts or inferences to be drawn from the facts, the case should be submitted to the jury. So that's why I asked the question the way I did, is because if you concede that reasonable jurors and reasonable persons can disagree about what they've seen on the videos and what those videos mean, then that presupposes or actually mandates that I deny your motion for judgment of acquittal at this point. Do you at least agree with that argument?
Well, generally, yes. My only pushback on that would be that unlike, I think, in some of the other cases that you've cited that I've read tape is, and just reading the case, what I think is different is here the jury has and the court has not just the video, but the audio. And the audio has the words from Mr. Gerder himself. And you can see and hear in that there isn't it isn't malicious, that we're in the sense that ill will and no educational purpose. It's quite frankly the exact opposite. What you see and hear is that he's saying that you did something wrong, and I'm trying to raise you to be somebody who's a good kid, not someone who is out there doing things that aren't good for himself or others, and you're going to go nowhere in life, and I want you to go somewhere in life. And there was some clips shown today where he's actually in the room going over homework with Ronan, and there's a lot of conversation about doing homework, and it's every time you see on the video that there is something that did wrong, whether it was impersonating a teacher at school or lying to somebody or lying to a teacher or those types of things, then the consequence you see on the video is that's when he got something taken away from him or he got in some way punished. And then he acts out again, of course, as a result of that punishment. And it's very sad to see how he reacts to that, of course, but that doesn't change the fact that the jury and the court has the evidence in terms of the audio as to why that conduct happened. It was not for no purpose or malicious purpose. It was for an educational purpose.
All right, so with respect to the aggravated child abuse count, without justification, is your position that applies to each and all of the different avenues which can be traversed in order to arrive at a conclusion of aggravated child abuse? Because the reason I ask it the way I'm asking it is, a couple of the avenues require great bodily harm. And I do have the question for both sides to address as to what, because there was evidence of mental injury. I don't believe there was any evidence of any great bodily harm. So the question is does any kind of mental injury rise to the level of where under the law it is considered to be great bodily harm? That's the first question. But this is the part of the information in terms of one of the prongs or one of the avenues that I want you to address specifically, and that is willfully tortured, maliciously punished, or willfully and unlawfully caged. And that does not require great bodily harm. And that what I've just stated to you are the elements of aggravated child abuse following that avenue. And address that, because it seems to me that on that basis
No,
alone,
the
I should be
jury
denying
is not
your
present
motion
for
for
this.
JOA on count one, because there's at least one avenue that jumps out at the court that clearly a jury would be the proper entity to decide, the issues in this case because of where the evidence stands at this point.
So interestingly, the jury instructions don't give us a definition of caged and whether it's temporal or not. And two things I would point out factually to the court. One is many, many times when the door closed in the video, you don't hear a lock. So the door isn't locked on many occasions. So Ronan could open the door and walk out, just like anyone can in any room. And therefore, those definitely would not fit the term of that level of confinement that one would say would be synonymous with the Webster's dictionary version of caged. There are times where he is, but there's a temporal aspect to that. And we heard it from, I believe it was Officer Lowe.
Let me ask, was there one time in any video that was played by the state where the victim walked out of the room without the parents opening the door first? I don't recall seeing a single instance of where that occurred.
That is true, but that's different because the door not being locked would not, in the terms of confinement under the law, in terms of like other types of cases or kidnapping cases or people being cuffed to things, you can decide not to go out. You can decide not to go out because there might be a consequence to going out and that you get in trouble because you weren't supposed to go out.
But why wouldn't that be a basis for confinement under the law where you have great fear that if you come out, bad things will happen to you? To me, is there anything in the case law that gives guidance on, because I'm not sure I agree with your argument that it wasn't locked, but that'll be up for the jury to decide. But the legal point that you're raising for me is whether confinement actually requires a lock or confinement be achieved by virtue of the inducement of fear in the victim. So the victim is scared to death to come out.
So
I really, really do like this judge. He's making now, if this guy was a better lawyer, I think that he could definitely argue his way out of a paper bag. But I like that this judge is really thinking through. He's not making a blanket statement. He's having these lawyers argue their case, he takes time to really think about the law, to ask questions, to make sure the lawyers are really, using the case studies. He's going through case studies himself. He's saying, "Hey, I cited this law. What do you think about this? I'm looking at it this way. This is what my thoughts are about it. What do you feel about this?" And I really like that this judge is taking the time and not texting his friends or doing whatever that one crazy judge I reported about was doing. I think he's giving this case, all the attention it needs, and I really appreciate a judge that is taking his time.
The difference in this particular set of circumstances, and the case law does say, I mean, not on cage per se, but on child abuses, and you just read it, Judge, it's very fact specific. So we're dealing with the facts here, which is parent-child, right? Parent-child in a situation where at times children get punished. If I send my daughter to her room and say, you're confined, you're not going anywhere tonight, you're staying in your room all night, I'll see you in the morning. It's not that she is confined in terms of caged under the law. She's not supposed to come out. Doesn't mean she can't come out. That is not a crime. That is not something where this court would find I committed child abuse. So I think there's a difference because of the circumstances between the two parties here, father, son. And clearly, as you can see in the video, every instance is tied to something that has done. He's admitted that on the stand.
But are you making the argument there that just because there might have been a legitimate purpose in the punishment, that a parent can never exceed, going back to the language used in the Tucker case, the Tate case, that where the punishment exceeds the permissible bounds of what is proper? To me, that presupposes there can be a motivation or a legitimate reason that started the punishment per se, but that punishment can go off the rails and exceed what is permissible in any reasonable society. I mean, you're not making that argument, are you?
No.
All right.
Of course, it could. And again, and as the court.
All right, so you just accepted that.
Yes.
So if you accept that, do you not agree then it becomes a jury question as to determine whether the punishment here, the specific punishment, crossed the bounds of what is proper in a society such that it could be aggravated child abuse? Because, I believe there's enough that they could define that the victim was unlawfully caged. And so if you concede that, doesn't it have to go to the jury to decide it?
So again, then we would say in every case that every case would then go to the jury, because it's a question of, do the facts meet the elements, right? And that's what I'm getting at, is that this specific set of facts.
Well, that is the question, but it also comes with a big proviso, provided at this stage, the state gets the benefit of all favorable inferences. So when you want to refer to that room as a structure, a box, or a cage, they get the inference that, hey, it's a cage, and it demonstrates caging at this point, don't they?
Well, I think caging, so the issue is that since my reading of the jury instructions, that there isn't a definition of the word cage. So, what we're really looking at is, and by all accounts, it's a room, correct? The caging aspect, is my understanding, would be, just from Webster's version, is that it's locked and confined and you can't get out. The only sort of caging case that I think I found in the fourth was Blow versus State. Doesn't really apply because it's handcuffed and chained to something, kind of a case. And quite frankly, in that case, they said the district court held that the plain meaning of the term cage does not include the act of chaining or handcuffing, and therefore the state did not present a prima facie case. And that's Blow versus State, 993 Southern 2nd 540. I'm sorry, that's a second DCA case, not a fourth. I didn't find one in the fourth.
Right. So, Mr. Wade, because I do think you might have a meritorious argument that there's some aspects of count one that should be narrowed. And so I want to focus on that, because that to me is where the real legal issue here is. In all of the avenues that are available for aggravated child abuse under count one, you agree that there's some that do not require great bodily injury, correct? The one I just talked about does not require great bodily injury.
Correct.
All right. So is your motion such that you're moving for a JOA on certain aspects of count one where great bodily injury is a requirement, and in your view, the evidence that's been presented by the state fails to demonstrate great bodily harm? Because if that's your motion, there may be parts that I need to have a conversation with the state about, because I have questions and they will need to explain to me where the evidence is of great bodily harm, if great bodily harm does not include PTSD or any mental injury. And if it doesn't, then there may be a basis to narrow count one.
So would it be both? Obviously, I'm moving for all counts, but as I made the argument, it includes what.
Yeah, you're going to lose on, I'm just going to tell you up front, you can make your argument for the record. You're going to lose on the willfully tortured, maliciously punished, or willfully or unlawfully caged. I would be denying that because I think it jumps out at me that there's enough evidence for that. But the others, I'm not so sure, which is why I want to focus on that, because that's where the bigger part of my effort needs to be focused on at this point, is if I have to narrow count one.
Fair. So my position on that, and obviously then I'll turn it over to the state, is that great bodily harm and permanent disfigurement, they are defined. Defined as great means great as distinguished from slight, trivial, minor, or moderate, and as such does not include mere bruises.
But it's got to be bodily harm, right? Physical
Bodily harm.
harm to the tissue, to the bones, to the skin,
Correct.
those kinds of things. Mental injury does not fall within that category.
Not on reading of cases that I've been
Right.
looking at.
Okay, so let me take you to the second avenue that it's kind of in the information as well. I marked it as number 2, the avenue. And that is that the defendant did an intentional act or actively encouraged another to do an act that resulted or could have reasonably been expected to result in physical or mental injury. Now that standing alone, you would lose because I think there's evidence of mental injury. But it looks to me like in that particular avenue that it carries with it the conjunction and that it still has to have or result in great bodily harm, permanent disability, or permanent disfigurement. Let me hear your comment on that as well, because I think you're making the argument that it applies, but I want to hear you say it so I can properly register it.
Yeah, it's a conjunctive. It's an and, not an or. Yes, I agree with the court on that.
All right, do you have any case law to where it's been interpreted that way? I mean, I think reading it makes me understand it that way, but it won't be the first time I've read a statute and there's an appellate case out there that interprets it in a way that I might not always have interpreted. Were any case?
I focused on the 4th and I used Wheeler versus State. It's a
Okay.
2016 case, 203 Southern 3rd 1007.
All right, and so the last avenue that's in the information, and that is did commit an aggravated battery upon RDF, the child contrary to Florida statute 827.03. By virtue of the aggravated battery, that presupposes and subsumes great bodily injury, doesn't it?
Yes, sir.
And so just mental injury would not be enough to sustain that prong. You agree with that?
Yes.
All right, so I'm in agreement with a substantial portion of what your argument here is. I haven't heard the state yet, but I see where you're going with your argument. I told you that I already disagree with you on the one avenue that talks about willfully tortured, maliciously punished, or willfully and unlawfully caged. Are you going to address count 2 or count 3 at this point, or is your motion only to address count 1?
That one.
Okay, all right, so let me turn it over to the state, and who's going to argue, Ms. Black? All right, so I've given you kind of a roadmap of some of the issues that I've already looked at, and I want you to address, and I saw you shaking your head back there when I was talking about the mental injury. You concede that mental injury does not constitute great bodily harm under the statute?
The statute is not, we are not proceeding under 1A or 1E. We are going under the theories of 1B, 1C.
Hello,
Okay,
Christine.
so let me
I
go
hope
through
you're
the
having a
information,
good
and then
day.
you can address it. The information says that, Christine and Timothy Fair on or about December 28, 2021 to January 28, 2022, and I'm going to cut through what I don't have to read, did knowingly, and this is what I consider the first avenue, did knowingly or willfully intentionally inflict physical or mental injury that resulted in great bodily harm, permanent disability, or permanent disfigurement to RTF a child. Okay, that presupposes the infliction of physical or mental injury. I think you have both of those here. There was physical injury and there was mental injury. The physical injury doesn't necessarily mean great bodily injury, but there was physical injury and there was mental injury based on the evidence that I've received. But that carries with it the additional requirement under that avenue that it has to result in great bodily harm, permanent disability, or permanent disfigurement. So my question to you is the state pursuing a conviction under that prong? All right, so that settles that. The motion for JOA on that prong is granted. So that won't be presented to the jury. So let's go to the second avenue. Did an intentional act or actively encouraged another to do an act that resulted or could have reasonably been expected to result in physical or mental injury? Again, just like the first avenue, you've got the physical injury and you've got the mental injury, but you have that little word there, and it says did result in great bodily harm, permanent disability, or permanent disfigurement to RTF. Is the state pursuing a conviction under that avenue? And you may want to address the word and what you think it means.
It seems like you are going off of the information, the charging document. We're going over the jury instructions as far as the elements.
Well, but the information tracks the statute, doesn't it?
Yeah, Your Honor, we're not proceeding under that prong. However, as to the great bodily harm, however, the lesser of child abuse includes the portion of that without great bodily harm.
Without great,
We would be asking going forward on that.
right. Right. I'm only dealing with the top level offense. So, and I'm ruling the way I am because of the absence of great bodily harm, but that does not negate the lesser included offense of child abuse, which doesn't require great bodily harm.
Christine, when you go onto YouTube on your little your YouTube, it on the left hand side, or wait, no, sorry, I have a terrible time with on the right-hand side, up on top, they'll have a little picture with like you, whatever you've created as your icon. Go in there, go to YouTube Studio, and it will have all of your information on there, and it will keep track for you and kind of give you little pointers. I can try to give you more information if you message me on the Discord for Dave. I don't, yes. And I did want to shout out Excited Utterance. Her tutorial on how to use Canva to make overlays is the first time in the history of ever that I was able to make an overlay without crying or cussing or Mr. Mo coming home and well, seeing me crying and cussing. So she made it so easy, and I recommend everyone, if you need to make an overlay, she has a couple different how-tos, and it is just amazing. And yeah, she's at 300 if you haven't subscribed to her, but she is doing the Lord's work, helping those of us who are technically challenged learn how to do these things. So I made this beautiful overlay with the tool, or just doing what she showed me how to do. And I did it without cocking it up. And that, my friends, is a small miracle. So yes, Sal, I shock myself sometimes.
Harm. So let me be clear on that. So based on that, what your deal with the and did result. Do you agree with at least the court's initial interpretation of that, and Mr. Wahid's conclusion as well, that in that avenue it requires that there also be great bodily injury?
Yes, it says and, then it
All right. So you're not pursuing that based on the evidence that the court received thus far. And then the third avenue, I've already ruled in your favor on that: willfully tortured, maliciously punished, or willfully and unlawfully caged, RTF a child. That one you are pursuing, and I would think that that's the major brunt of the state's case in regard to count one. Am I correct on that?
Yes, Your Honor. And just to kind of address what defense said in their argument as far as Blow versus State, in that case, it did not, that they said that caging does not include chaining a child, but they did talk about how the caging aspect is a wire or bar box-like structure or a small restrictive.
Yeah, you don't need to spend any real time on that, because I've sat through the hours of video as well. It can be up to these folks to determine if that's a cage or not. What I'm concluding is there's enough evidence for them to determine that it could be. So it's going to be up to them. And then the last one, which I consider to be the fourth avenue, is did commit an aggravated battery upon RTF. Do you agree that that presupposes great bodily harm, so you would not be pursuing the charges or conviction under that avenue?
Correct.
Okay, so here's where we are with what will be presented to the jury if we get there after the presentation of the defense case in this matter. So count one, so the motion for JOA is granted as to count one with respect to everything except the requirements in the avenue of willfully tortured, maliciously punished, or willfully and unlawfully caged, which, based on the court's conclusions as to the evidence up to this point, that would be presented to the jury to determine. That does not mean that the lesser included offense of child abuse will not be presented, because it will, because that does not include the element of great bodily harm, which is the primary impetus behind my rulings in narrowing down count one. So everybody with me on my rulings on count one? So I think I've covered everything I need to cover in terms of my rulings. Is there anything else, Mr. Wahid, that you would need me to address from the standpoint of your motion for JOA? Okay. Any clarification? Okay. All right. And the court will reiterate and reconfirm its prior rulings in regard to all the motions and objections that Mr. Wahid and the defense have made during this proceeding. If that's what we're just renewing all of that so that they're the same ruling as before. Ms. Black, anything that you ask or need clarification from the court on as far as my ruling?
No, Your Honor.
Okay. All right. So at this time, Mr. Wahid, it's appropriate for me to ask before I bring the jury out is, do you intend to put on a defense? All right. And have you made a decision at this stage as to whether your client intends to testify so that I can conduct the necessary colloquy? All right, so you want to do those witnesses before you make the decision as to whether your client will testify or not? Okay, all right, so that just means that I'll defer the colloquy for you, Mr. Farrader, until such time as we're at that point where you have to make a decision whether you're going to testify or not in your own behalf. You understand all that, sir? Okay, good. All right, so Mr. Wahid, I don't see Ms. Murad. You want to take 10-minute recess before we start? All right, so we're going to be in recess for 10 minutes.
I renewed my objection to, in light of the testimony to Kellen McCoy, who is the teacher, about the incident where he embarrassed his sister, as that is not an issue in dispute. It was disclosed by the child during his testimony, he fully admitted to it. And to have an additional witness testify to the same event that is not in dispute would be cumulative, especially when it's a prior bad act of the victim.
Mr. Wahid, do you want to address that, or is that for Ms. Murad? Let's get you mic'd up over there. You're good.
Yes, so that incident results in a response from Fairders, which goes to part of our case, which is that they engaged the school, they took the time to listen and understand what happened and gather all the facts before doing any sort of response to. So going through that process that the Fairders went through goes to all of what we're saying, that their conduct is not malicious, that it is educational, that it is parental, and it drives directly to a parental defense.
Is she going to testify to anything else other than what was admitted by the victim on the stand?
Yes, she's going to testify to the fact that the Fairders
Okay.
engaged with her.
Ladies, can we have a talk about the shoulder ruffles coming back? Look, I have linebacker shoulders. I'm also a bit fluffy, admittedly, but the shoulder ruffles, can we stop that too? All the shoulder ruffles must be stopped.
In the school, and exactly what I just said.
And she's a
learned.
teacher?
She's a teacher.
And Your Honor, if you'll recall, the child testified to those specifics, that there was a meeting, that his mom had a meeting, and that his dad came, and that he went into the room with the teacher with the dad. All of the facts in which he's going to elicit have already been elicited without dispute.
Yeah, I'm going to deny the motion. I think the defense is entitled to call the witness because she may have a flavor that the victim himself didn't present. And so you're entitled to present your defense, and I'm going to allow that witness to testify. Consistent with the scope and the parameters that I've already set out many times already with my in limine rulings.
Understood.
Okay. All right. Can you let the jury know it'll be 10 minutes, and then we'll start back up with the defense case. All right. Court's in recess for 10 minutes.
Two witnesses that will testify by Zoom. We're going to do them first. So if you could just make sure they're there.
Let me pull up my email here.
Thank you. I emailed Ms. White directly, so it may not be there.
Well, she would send it to me. So let me just see if I've got it here. You sent it to division. So, ladies and gentlemen of the jury, we have now, as you know, completed the state's portion of the case. The state has rested. And as I advised you at the very beginning, the defense has an opportunity to put on a defense if they wish. They will be calling witnesses. So we are now in that portion of the case called the defense's case. And with that, Mr. Wahid, does the defense have a witness to call?
Yes, Judge.
All right.
This time, the defense calls Kellen McCoy.
Okay. All right. Before
Okay.
We administer the oath to Ms. McCoy,
This is
testimony is being conducted via Zoom by agreement of the parties. The witness will be sworn in. And again, you are to
The
view,
teacher.
listen to the testimony the
Uh,
same as you would if this person was sitting right here on the witness stand here. Everybody understand that? Okay. All right. So, ma'am, I'm going to go ahead and administer the oath. If you could raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right, Mr. Wahid, you may proceed.
All right. So, and it's a little weird. I'm not facing anywhere, but I'm actually facing the camera. So hopefully Ms. McCoy is looking at me as I ask the questions. Ms. McCoy, if for some reason through technology you don't hear what I say, please, ask me to repeat it. And of course, if I ask a question that doesn't make sense, which happens a lot, just go ahead and tell me to repeat that as well. Ms. McCoy, can you?
I think I'm going to make it easier on you. I'm going to switch the video for her. So she just look right at that video there.
Okay, great.
All right, you have to see.
Can you please state your full name?
Kellen Marie Hynum.
And what was your maiden name?
McCoy.
Okay. So currently, are you working?
No.
You're home with a fairly young child, correct?
A couple, yes.
Okay. Back in
I feel that
2018-19, were you working as a teacher?
Yes.
Okay. How long were you teaching?
At that point in time, maybe four or so years.
And what city did you live in at that time?
Tucson, Arizona.
What school did you teach at?
Immaculate Heart Academy.
Was Immaculate Heart is that a private school? Public school?
hello, Bobby.
Private.
And what grades did you teach back then?
I taught second grade, third grade, and fourth grade consecutively.
And do you recall,
I'm
in
not laughing.
20
I'm laughing at the child trying to get on the thing because I have had that happen before.
18 were you teaching?
I'm not certain. It was either third or fourth grade.
So do you know the name Farrader?
Yes.
And how do you know her?
She was a student of mine.
And do you remember when that was?
2019,
In 2019?
I believe 2019.
Okay. Was there ever some moment
She needs a
where
water bottle.
his brother comes into your classroom and asks you to make an announcement? Do you recall that?
Yes.
You recall when that was approximately?
Can you repeat that question?
Sure. Do you recall when approximately what month and year that happened?
Off the top of my head, I can't remember for sure. Maybe February of 2019 or March.
All right. And would it help if, to refresh your recollection, if you had something to look at from that time?
Yes.
So earlier today, my office should have emailed you a document. If you
Okay.
take a look at that and tell me if that refreshes your recollection as to the time frame we're talking about.
Yes. 1 second.
Sorry.
March of 2019.
All right. So March of 2019.
Me too. I am waiting for
And
her to do the
tell
mom
me,
glare.
what you recall happening between and in your class.
He came into my classroom and asked if he could make an announcement to my class, which at that point in time, it was a regular thing for teachers to send students to other classrooms to make announcements. So I said, yes, you can make an announcement to the class. So he walked to the front of the class and started to say things where I quickly realized he was not sent by another teacher. He said some things to humiliate her in front of the whole class. He made her cry. And once I caught on to this wasn't to the fact that he was not making an announcement sent by another teacher, I stopped him and I asked him to go back to his own classroom.
And did he leave?
Yes, he did.
Did you notice any response from?
Yes, she was very, very upset. She was crying, and it took a while for her to gain her composure.
Oh,
What was your impression of that whole incident? I'm sure
Sustained.
had you
My
I'll ask another question. Had you ever had something like that happen in your class before?
Sustained.
Based on what happened, did you do anything next? Did you reach out to the parents?
Yes, I did. I
And
sent them an email.
generally stating what had happened, correct?
Yes.
And what, if anything, was their response to you notifying them of this action?
They came in immediately, I believe later that day, to talk about it. They had requested that they meet separately. So first I met with mom and talked
Okay,
to mom about what had
so
happened.
what I have gathered from what he said and why he said it, from the notes I have on the testimony, is that the sister and all of the other siblings, and this was around the time that he was being, or the parents were being told by the pediatrician to cut his sugar down. Now, the siblings were still allowed to have some sugary snacks. I don't know what the regimen was like, if the family, everyone didn't get sugary snacks or what have you, but he was irritated that his siblings were not being limited in their snack choices like he was. And he decided that day that he was going to punish his sister for being allowed to still have, I don't know, fruit snacks or something. And he decided that he was going to do that. From what I've heard in testimony, what he said in his own testimony is that he was upset that he didn't get fun snacks. I wonder what he said. I mean, he does sound like a pot stirrer, a poo stirrer, if you will. Yeah, and my guess is if I know brothers and sisters or myself as a pesky older sister, if my brother was not allowed to have something and I was allowed to have something and I was a 4th grader, would I be eating it and savoring it with glee and relishment in front of him just to tick him off? Of course I would, because I was a jerk. So,
And then after that, I met with dad separately to talk about it. And while I was talking to each parent, the kids were waiting by themselves, either in the hallway or in their car. I believe I may have been in the car while mom was having a meeting with me, or in the hallway, and was in the hallway while I met with dad.
So let me talk to you about the dad response, Tim Fairder's response. When he met with you, once you conveyed, so let me ask you, what is it generally he wanted to know about?
Well,
Trying to avoid the hearsay, just
I'm
generally.
going to overrule the question as phrased, but ma'am, you're not to say what Mr. Farrader said. You're only supposed to state what your understanding was that he wanted to know. You can answer subject to that limitation.
So what did he want to know?
again, why are we letting this lawyer ask the questions? He cannot form questions. He cannot answer questions. He can't change the questions that he wants to ask in a way that will not be hearsay.
can I continue?
Yes, you can state what was your understanding of what he wanted to know.
My understanding is that he wanted to know the facts of what happened. He seemed concerned and wanted to just understand what the situation was. And he was very,
Go ahead.
he seemed very receptive and understanding of what had happened.
Did he, in your presence, ask you any follow-up questions regarding trying to determine if there was any punishment from the school, detention, or if the school was taking any action against Ronan?
Not that I can recall.
And did he give you some indication that they would handle it as a family at home?
That was my impression, although he didn't, I don't remember him stating anything directly saying what they were or weren't going to do at home.
Was there any impression you got from that interaction as to what, if anything, he was going to do next?
Sustained.
No.
Lucy,
Based on
that sounds like
interaction,
something my son would
so
say.
you had a separate interaction.
Mr. Wade, let me just make sure the witness knows. When
Oh, okay.
I sustain an objection, ma'am, that means you're not to answer it, okay? Do you understand that? And I sustain the objection to the last question, so the answer is stricken. Jury is instructed to disregard it. You may continue now, Mr. Wahid.
You had a similar conversation with the mother, correct?
Yes.
Did the mother also inquire of you as to essentially facts of what happened?
Yes.
Based on that interaction, did mother give you any impression as to, or ask you if there were any consequences at the school that were going to take place?
Not that I can recall.
And continued to be a student in your class, correct?
Yes.
One
moment.
Granted.
No other questions for this witness.
All right, any cross by the state? All right, Ms. Coakley, you may proceed.
You were a fourth grade teacher, right?
I believe so, yes.
And at the time that this happened was also in elementary school, correct?
Yes.
So like he was one grade above us, so he was a fifth grader at the time that this happened?
Yes, I believe he was in 5th grade.
So he was approximately 11 years old when this happened, correct?
That sounds right, yes.
And the date that it happened is March 22nd, 2019, right?
Yes.
And you sent an email to the parents, correct?
Can you repeat that?
You sent an email to the parents to notify them of the incident involving their children, correct?
Yes.
And you told the parents that what occurred is that you came into your classroom and asked to make an announcement.
Let me stop you there. Ma'am, it looks like you're typing on a keyboard and you cannot be reading anything or typing anything while you're testifying. So just please acknowledge to me that you're not reading. Yes, it looks to me like your hands were moving. All right, I just want to make sure, anytime I'm doing remote testimony, I just need to make sure the witnesses understand the restrictions that you cannot be reading anything or typing anything or communicating with anyone else. You understand that?
I understand that. I'm just watching my kids.
Okay, perfectly understood. But anytime the eyes start darting away, I have to be careful that you're not getting improper influences. So you may proceed. I just want to make sure you understand the instructions.
And what said in front of the class was, I've gotten several reports about stealing in this class. Stop. Just because I'm your brother doesn't mean you can do that. And then he asked me to stand up, correct?
Yes.
And that made me cry, correct?
Yes.
Oh, so he told
That's all
her.
that he said, correct? Before you
He-
stopped him.
No, that's not all that he said. Those are just the specific words that I remembered as I was typing that email.
Right. That's all the information that you provided to the parents, right? That he came into class and he accused his little sister of stealing, correct?
That is all the information I provided in the email. Yes.
Now, you did speak with the parents, correct?
Yes.
You were not aware at the time how it was being treated by his parents at home, correct?
Correct.
You also are not aware of how the parents chose to punish their 11-year-old son for this infraction, or are you?
Correct. I was not aware.
They didn't tell you what they were going to do with this information, correct?
They did not tell me.
That's all the questions I have.
All right, any redirect, Mr. Wahid? All right, you may proceed.
Ma'am, the state referred to this as an infraction. At the time when it happened, in your mind, was this an infraction or a prank or something like that?
Objection, Your Honor, relevance.
Overruled, you can answer.
Can you repeat the question?
Sure. The state, just when they asked you, referred to this incident as an infraction and I'm asking you, at the time when you were there, was it your perception this was an infraction or a prank or something minimal like that?
What's the definition of an infraction?
Sure. So did you think this was just a prank between siblings? Did it come across to you as that, as something in play?
No, it didn't seem like a simple sibling prank to me.
And why?
Sustained.
No other questions.
All right, thank you, Mr. Wahid. All right, ma'am, that concludes your testimony. That means that you may sign off and your testimony is concluded. She's excused from further proceedings, correct?
Yes.
All right, you may sign off, counsel. Ma'am, thank you.
Thank you.
All right, Mr. Wahid, your next witness.
I'd like to call Steve Johnson.
Okie dokie, we have Steve Johnson coming next. And who might he be? Please let the person who came up and let him audit his class be Steve Johnson.
I see him in the corner there, Judge.
All right, Mr. Johnson, this is Judge Coates in Palm Beach County, Florida. Can you hear me, sir?
And Freiber is just napping
can.
right
Okay,
outside
you've been
of
called as a
camera
witness in
view.
the matter of State versus Fairder. First order of business is for me to go ahead and administer the oath. If you could raise your right hand, please. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do.
Okay, all right, Mr. Wahid, you may begin.
Thank you, Judge. Sir, can you state
So
your name? And,
what he said is he had his sister stand up, and what the teacher basically said was, we've had reports of stealing in this class, and just because I'm your brother doesn't mean you can get away with this kind of stuff, and more things of that nature. So apparently he accused his sister of being a thief and was making it pretty apparent that she was the one doing all of the skullduggery, if you will.
what city you currently reside in?
Sure. My name is Stephen Johnson. I live in Tucson, Arizona.
And how long have you lived there?
My entire life, 40 years.
Are you currently employed?
I am.
Generally, what type of work do you do?
Director of Business Development for a pain clinic.
Do you have any children?
I do.
How many children do you have, sir?
9.
9?
You're busy.
Correct. Apparently.
Do you know someone named Tim Ferreter?
I do.
And how do you know him?
I met Tim back in 2017 at a basketball camp for our daughters when he first moved here.
Here being Tucson, Arizona, correct?
Correct, here being Tucson, Arizona. And then subsequently learned that his children were going to attend the same school as mine, Immaculate Heart in Tucson.
And what would you say was the frequency of contact between you and Tim Ferreter back in those years?
At first, not much, but he and I coached basketball together for 2 seasons. We coached our daughters. And so that would have mean I would see him probably 3 or 4 times a week.
And do you recall his son?
I do.
And do you recall when you approximately when or how you first met?
And then at one of the practices, his dad introduced him and he sat and watched the practice. And then he was also in my son's class at school.
So your son and his school went to school in the same class?
That is correct.
At any point, did you go to Tim's home?
I did.
And can you tell me what those occasions were about?
Hmm.
Why'd you go?
Initially, they were social. There were for some kids' birthdays and the baptism of their youngest. And there were a few times that I was over there for business. Tim was a publisher of a magazine, and I was learning how that worked from him at his home during the day.
Interesting.
And so did you at any point see the inside of Tim's house?
Yes.
Did you ever were you ever shown his room?
I was. That is correct.
Who showed you that room?
I believe Tim would have given me a tour my first time there.
Did you at any point at that time, do you recall interacting with him yourself directly?
Yes, I did interact with him several times. He was always out with the family and the guests when we were over there.
In your interactions with Tim during that time, did he seem guarded or any way secretive about his family?
No.
Hmm.
And did you ever have occasion to see
You can fake a normal
or
family
interact with him
for
enough to
gatherings.
a gauge on his behavior?
I did, and was always pleasant. He'd always have kind of a sly smile on his face. He was talkative, so we connected pretty easily.
And did you and Tim and your son ever collectively engage in anything?
Perhaps within those social settings, we never had anything particular for the 4 of us.
And I know you guys were teaching, we're coaching girls basketball.
Yep.
And do you know if either did you ever see or know that was engaged in any extracurricular activities back then?
No, I know that he didn't play any sports.
Right.
That I do know.
Did you on any occasion see the interaction between Tim and?
Yes.
How would you describe that interaction?
Oftentimes, because we'd sit and watch the practices, there would be some times when Tim would go over to help him with homework or something that he needed. Common if a kid is near a parent. There were times when we would be at a game and I'd show up and I'd notice that he had a notebook out and he'd be writing, "I will not hit my sister," 50 times or whatever the number was. And the reason that's
Mr. Johnson, there's been an objection. You cannot say what someone said or what they wrote. That's hearsay. That part of the answer is stricken. The jury is instructed to disregard it. All right, you may continue with your next question, Mr. Waheed.
Without saying what he was writing, you saw him writing things at the practice, correct?
correct.
Okay. And did you have any understanding of why he was doing those writings?
I did.
And what was your understanding?
I'm going to sustain it, but let approach, because you may have an exception you're going to rely on.
Yeah, Bobby, you can, like I said, you can fake being normal for gatherings and out at practice if you want to. I really don't understand why the female lawyer keeps letting cousin Lemmy talk. He has not struck me as completely competent this entire time. I will say that, like I said, I mean, I have rarely seen a judge do his homework and, anticipate, hey, you might have an exception and hearsay on this, giving the defense, a chance to argue things, even if he doesn't maybe disagree with their stance. He's kind of made, his sort of thoughts about the case known, but he continues to let the defense argue their case, and he's listening, and I really do appreciate it. This judge would be cool to go get a beer with. He wouldn't be as fun as Borowski, but he seems like he'd have a couple fun stories to tell you. I don't get the tapestry jacket. I don't get it. I really don't. But it looks comfy, and I'm all for comfy. My sweatshirt today says, I don't need a man, I need the house from Practical
The
Magic.
objection is sustained. Next question, Mr. Wahid.
Sir, did you observe Tim be affectionate to?
Objection relevant.
Sustained.
Did you ever observe Tim disciplining?
Yes.
Did you observe an interaction between them where Tim was not disciplining?
Yes.
Would it be fair to say that they, in your mind, that strike that? Did show affection for Tim?
Objection relevant.
Yes.
I overruled. I'll allow that question.
Yes.
Did you ever observe Tim disciplining the other children in his family?
Yes. Yes.
And so we're clear, you knew Tim and you were interacting with Tim during 2017, correct?
Correct. Yes.
2018
Yes.
and into 2019
Yes.
until his child left Immaculate Heart and went to another school.
Until they left for Florida, I believe.
Okay, so even when switched schools, you were still interacting with Tim and his family, correct?
Correct.
No other questions.
Thank you, Mr. Wahid. Any cross? All right, Ms. Black, you may proceed.
Good afternoon, Mr. Johnson. Can you hear me?
Yes, I can. Good afternoon.
So you stated that you kind of became friends with Mr. Ferreter back in 2017?
Correct. Yes.
Okay, and you both coached your daughters in basketball?
Yes.
Okay, you stated on direct that you had seen a room, right?
Yes.
And that was inside of the house.
Correct.
And that was before had been born, right?
That is correct.
Okay, so you don't know where he was living after it was born.
That is correct.
You also stated that you did not see a structure in the garage, right?
That is right.
And you didn't really have any contact with Mr. Ferder when he had decided to move to Florida.
Aside from a few text messages wishing things like Happy Thanksgiving, no,
Okay. So you never went to his house in Jupiter back in December of 2021.
that is correct.
You never saw where Wynn was living at that time, right?
That is correct.
You never saw the structure where Wynn was living in, right?
I'm sorry, one more time?
You never saw the structure that had been living in
I did.
2021?
I did not.
And you weren't made aware of how the defendant had been disciplining him at that time, right?
I had not been made aware of any specifics.
1 minute, Your Honor.
Granted. All right, any redirect, Mr. Wahid? All right, thank you, Mr. Wahid. Mr. Johnson, that concludes your testimony. Is this witness now excused? Okay, all right, sir, your testimony is concluded, so you can go ahead and sign off Zoom. Thank you for being here. Have a good weekend.
Thank you, Your Honor.
Okay. Well, they seem to be going through witnesses. Hopefully they've got a,
All right, Ms. Murad, Mr. Wahid, call you next witness.
not sure that one did anything for them. I mean, again, you can pretend to be a great person when you're at a baseball or basketball practice. And, you know, I am beginning to wonder if a female attorney is with child and he is going to be taking over for her when she's on maternity leave. And that's why he's taking point on this.
And Mark, when you come in, you can go ahead and change the input on the screen so the jury's not burdened with the Zoom link.
Because she seems to be the more agile attorney, but she seems to be kind of taking a back seat.
Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
All right, Mr. Wahid, you may begin at your convenience.
Sir, can you state your name and spell your last name for us?
Sev Debazati, D-E, B for Bob, O-R-Z-A-T-T-I.
And where do you live?
I live in Melbourne, Australia.
And how do you know Tim Ferder?
Yes, I do.
How do you know him?
I met Tim when we were at seniors in high school in 1992. I was an exchange student. I met Tim then, and we've been friends ever since.
Where was that?
That was in Milford, Michigan.
Okay. And over the years, you and Tim have interacted continuously, correct?
Correct. We've probably seen each other on 9 or 10 occasions in person, and we've stayed in contact via phone and FaceTiming with our kids and so on and so forth.
And your children know his family, correct?
Correct.
And you actually visited his house in 2013, correct?
Correct.
And then again in 2019, correct?
Correct.
All right. So I'm going to take you to 2019.
Mm-hmm.
So in 2019, tell me if you remember approximately when in the year did you visit his house?
It would have been July.
Right. Sir, move up to the mic just a little bit closer and speak a little bit louder. I want to make sure you're getting accurately recorded.
Sorry, July.
All right. And where was that home?
That was in Sedona.
The home was in Sedona?
Yes.
Was the home possibly in Tucson?
Tim's home was in Tucson, but when I first got there, we went to Sedona.
Understood.
Yeah.
Okay, so let's start with Sedona. So you were with your family?
Correct.
And how many children do you have?
3 children.
Okay. When you went to Sedona, were you with Tim's family?
I went with Tim. Tim met us in Phoenix. We drove up to Sedona to meet Tracy.
And what type of structure did you all stay in?
It was a 2-story home. Tim and his family stayed on the top level, and my wife and my kids stayed on the top level.
And do you know where did you sleep during that time?
I slept in the master room with Tim and Tracy.
And how long was that time that you guys were in that house in Sedona?
Approximately 5 days.
It was just a vacation in Sedona?
Correct. We went there. They had a softball tournament. So obviously Tim and Tracy took her around to all the softball tournaments that she could play, and it was a big one. And they invited us to come down and spend some time and do that. So we went down there for the softball tournament.
Subsequent to Sedona, where did you all go?
We hired an Airbnb in Tucson, 2 or 3 minutes from where Tim and Tracy live.
Did you on that trip have occasion to go to Tim's house?
Yes, I did.
And when you went to Tim's house, did you look around the house?
Yes, I did. Tim showed me around.
And did you interact with him on that day?
Yes, I did.
And what if anything, did you do?
Just normal kid. He spoke to me and showed me around, showed me his room, as all the kids did, and was happy to show me and was excited and showed me his toys and books and so on and so forth.
And where was his room?
His room was in the garage.
Hmm.
And did you have any occasion to see when interacting with your children?
Yes, I did.
And one of your
No,
children
your
is
first question should have been, were you confused about why he was living in the damn garage? Did him living in the garage give you pause? And then Aussie Man could have said, well, I thought it was weird, but it was a good room. It was a full room. And, they kind of had a bunch of kids. I thought strange, but it was a full room. I saw he had toys. It didn't give me pause to, immediately think child abuse. But this lawyer is ridiculous.
Correct.
What's that issue? If you can tell us.
So
youngest son has
ignore my
autism.
last comment.
So in the interaction that you observed between and your children, did anything occur that concerned you?
There was an incident in the pool where would be overly aggressive, duck the children underwater and hold them down there for a little bit and so on and so forth. So yeah, but I mean I was there, so I was there to protect and look after them, but I wouldn't have left my children alone if it was just grown kids.
So don't kids play like that, putting their heads underwater, that sort of thing?
I think when both of them choose to do it together and they play, this was more just one pushing the other down against their will.
And with your special needs child, did that give you any extra cause to pause?
Just maybe keep an extra eye out, just to make sure everything was okay, and I kept an eye on where he was and where the rest were.
Were there decisions made about going out for dinner or things like that with Veriters that factored in any way?
We always went out together, so we never left any of the kids behind. We're always as a group, as a family. We went out together, we ate together, we swam together, we played together, we did everything together as families.
Right. One moment. Going back to Sedona for a moment, was there ever an incident there that happened with that caused you concern?
When we were leaving and we were packing up and I guess checking the house before we left, we noticed there were knives missing from the kitchen. So we started to look for those to make sure we put those back and find out where they were. We couldn't find them, and then Tracy went into the bag to have a look and found the knives and brought them back, and we put those away. So there was probably a handful of knives that were missing and found in his bag.
No other questions.
Any cross? All right, Ms. Black, you may proceed.
Okay. Yeah, I've not been super impressed with the defense witnesses. Now, my previous comment you can take back because he did say that the room was in the garage. But I have not been impressed with his questioning because he could have asked right there, again, did it bother you that this child was living in the garage? Because that would have been my first question. That would have taken all the wind out of the sails of, I'm sure the state is going to come out and say, were you concerned about this child living in a garage? Like what? Again, you address the elephant in the room, is my assumption. As a non-lawyer or as a juror, that would be the question I would ask. Like, why the hell is he living in the damn garage? Now, I would also be very concerned about the knives. But Yeah, he's not a graceful questioner. I mean, but not every lawyer is going to be a Sheriffisi from, the Rittenhouse case. Not every lawyer is going to be, you know, a Johnny Cochran. So I guess, you know, you're going to have your lawyers that are really good at one thing and not good at the other. So I guess we are seeing that.
I just want to get your last name right. It's Mr. Debrazzati?
Debazzati, yep.
Debrazzati, okay. So
That's why I put
when did you
Aussie
first
man.
meet Mr. Fareder?
1992,
And you've been friends ever since?
correct?
You stated that you visited his house back in 2019,
Yes,
and this was after the vacation you guys had taken to Sedona.
it was right after,
Okay. So you stated that you saw his room, right?
correct?
And did you stated that it was in the garage?
Yes.
Okay. Did you see if there was a bucket in there?
No, I did not.
Okay. Did you see whether or not the door locked from the outside or the inside?
The door was open, so I was unaware of any lock.
Okay, did you see if there was a light switch inside the room?
I didn't look.
Was there a bathroom inside of that structure?
There wasn't a bathroom in the structure, no.
Now, you stated about an incident with the kids in the pool.
Yes.
Okay. And isn't it a fair assessment that they were just horse playing in the pool?
Yeah, like I said before, I would normally say that if there was two interacting together and playing, but this was more one imposing his will on the others. The girls didn't really want to play. They didn't want to be ducked or really horse played, but he continued to do it. So I
How old was he at that time?
think he was 11.
So he's basically being like the annoying older brother at that point.
Yeah, annoying. And
Oh,
yeah,
okay. I have to interject. As an 11-year-old, yes, they can be wild, but that's at the age where, if I sit down and talk to my son about you're the older kid and you need to set a good example, that generally gets through to him that, hey, I can't be rough and I have to use my strength to protect and not punish or not inflict my strength on others. Now, granted, he's a little toothpick kid, but again, instilling those kind of lessons of greater power doesn't mean you get to inflict it on smaller people. It means you are a shield, not a sword. Those are, again, lessons that an 11-year-old can grasp. So he's just being a jerk. I mean, I understand 11-year-olds can be jerks. We all went to middle school. But it is a concept you can grasp at 11, and he should be able to grasp it at 11. If an adult tells you to knock it off, you knock it off.
yeah,
But you were there to protect them if they needed to be protected.
absolutely. I wouldn't have left.
You also talked about an incident with some knives.
Correct.
Okay. And the fact that Tracy had taken them
From his bag.
he didn't threaten you with those knives?
No,
He didn't threaten the kids with those knives?
not that I'm aware of.
He didn't threaten Tracy with those knives?
Not that I'm aware of.
It's just that he had the knives and he took them out of the bag.
Correct. Yeah. So I don't even know if he knew how long he had them for.
Now, did you ever visit the Fareders house in Jupiter in 2021?
No.
So you don't know what the living arrangement was at that time.
No.
You don't know if there was a similar room that there was in Arizona in Jupiter.
No.
Woman, Your Honor.
Granted. Any redirect, Ms. Waheed? All right, looks like you do, so you may proceed.
Sir, would you have left your kids with unsupervised?
Objection relevance.
Absolutely not.
Overruled.
I'm sorry, sir,
Absolutely not.
and why not?
I would think it would be unsafe.
Thank you.
All right, is this witness testimony concluded at this point? Excused, I should that concludes your testimony. You may step down. Thank you for being here. Call your next witness, Ms. Murad or Mr. Waheed. Are you doing the direct, Ms. Murad?
Oh, thank you, goodness. Okay, this might be their clinical psychologist.
All right, Ms. Murad, you may begin.
Thank you, Your Honor. No worries. Sir, could you state your name for us, please?
Yes, is the microphone all right?
Yes.
It
ma'am.
is.
Stuart Graham, like the cracker, Graham.
Dr. Graham, could you take us through your educational experience?
I can. I have a baccalaureate degree from the University of Texas at Austin in microbiology. I have a medical degree from the University of Texas Medical Branch in Galveston, Texas. I completed 2 years polymedical school postgraduate training in anatomic pathology at Case Western Reserve in Cleveland, Ohio. I am a pathologist by training. The one part of after medical school of training in pathology is called anatomic pathology. That's the specialty of pathology that most people think of as being real pathology, where you perform autopsies, you receive specimens, you look at those specimens under a microscope, and you then reach conclusions regarding disease. Following completion of 2 years in Cleveland, Ohio, in anatomic
Oh, really?
pathology, I then completed 2 additional years of training in clinical pathology at the University of Texas Health Science Center in Houston, Texas. Clinical pathology is another branch of pathology which deals with the study of disease in human beings. It differs though.
I don't know. I feel like I want to get this tie for David. It's got unicorns in a field of noisy green and purple and blue. I just feel like it's a tie that David would never wear, but I would always ask him to wear. And I feel like,
Differs though in anatomic pathology.
oh,
and
the
that rather
Australian
than
friend.
looking at
Yeah, not really.
portions of the body either with the naked eye or under a microscope, the disease processes rather are studied by the use of laboratory tests. And the part in clinical pathology deals with the implementation of laboratory tests and the interpretation of laboratory tests. Following those 2 years, so now we're 4 years following medical school, I completed a 5th year of training after some time in the subspecialty of forensic pathology. I completed that training at the Office of the Chief Medical Examiner in the city of New York. Forensic pathology, as you may know, is the area of pathology which deals primarily with the interaction of disease and injury in the human body. And as such, forensic pathologists are often asked to make determinations with regard to what natural disease did a person have, what injuries did they have, and what was the result of those natural diseases and or injuries. I would say that the injuries can be of a variety of sorts. They can be, of course, violent, either with a hammer, with a knife, or with a gun. But injuries can also be those of withholding things, such as food. It's possible to starve a person to death. Following completion of that fellowship, I then after that sat for the American Board of Pathology certifications and passed those my first time in anatomic pathology, clinical pathology, cytopathology, and forensic pathology. After completion of and receipt of my certifications, I've been active for the past, gosh, I am old, 30 years.
Oh,
And
I love this guy.
the,
I want to adopt him.
30 years in the performance of surgical pathology.
I think you're right, Lucy. I really do. They should have focused on how many doctors they went through, how many their actions, how if they'd gone to therapy, again, show all the steps they went through and how, they definitely tried to get help and they just couldn't. I think it should have been more on, look, we tried to get help this way. We went through after school programs. We went through, trying to get him into sports. We went to trying to get him into mentoring, this kind of stuff, that kind of stuff. Not he was obviously put his behavior there because you have to have a catalyst for them going to different places. But if you bring on the pediatrician who can show, at every single well child visit, they're documenting, more behavioral issues, have them bring in teachers that say, hey, I've gotten more behavioral, demerits or whatever. I do think that you're right, Lucy. I think that going after the child's behavior was not the strategy that they should have gone with.
which involves the study of specimens from live patients, and for 13 years in forensic pathology, which, as I said, is a little bit different of a specialty, which involves the inclusion of injuries as well. At this time, I most recently now work as a forensic pathologist in a variety of capacities. I do per diem work. Most recently, last year, I was at the last year I was in Webb County, Texas, on the Rio Grande, working as a medical examiner for 3 months, which, as you can guess, was quite busy. I also perform private postmortem exams on behalf of families and hospitals. And finally, I do consultations both in civil court and in criminal court, as we are here today.
And in this case, were you hired by my firm to review some records and come to an opinion regarding a particular issue?
I was.
Okay. Could you take this jury through the records that you reviewed?
I will. The records I reviewed were the Palm Beach Sheriff's Office of offense report, the Children Protection Services report. There were some photographs associated with the Children's Protective Services report. There were health records from JFK North. There were also pediatric records from Infants and Children's, which is a large group of pediatricians, which took care of. And I believe that's about it.
So I want to talk specifically about the infants and children's records. What years do those span?
Well, the records span. The records span from the time that is 8 years 8 months up until the time that is 13 years 3 months, or thereabout. In other words, approximately from June 1 of 2016 until December 21st of 2021.
Okay. Based on those records, what is your opinion regarding nourishment, health, and weight?
Based upon those records, it's important to note that the records include within them a calculation which is endorsed by the Center for Disease Control and Prevention, the CDC. And because that the assessment of nourishment is a national importance in pediatrics, there's a standardized way of doing it. And for each child, for their particular sex and their particular age, a calculation is performed that's called a body mass index. Well, we can call it BMI for short. But the importance of the BMI is that it takes the person's height into account and their weight to give a calculation, so that for a person's sex and age, you can compare an apple with an apple. And so that you're not comparing a child's weight without relationship to their height, which obviously would cause obvious problems. The BMI then, which is endorsed by the CDC, those records were included in the ones that I reviewed, and there's a chart, and the chart shows that in 2016, when he was 8 years 8 months old, his BMI had a numerical value of 40. Later, in December of 2021, his BMI had risen to a value of 56. Now, it's perfectly fair for you to ask me, well, what does 40 mean and what does 56 mean? It's actually quite simple. For a BMI of 40, it would mean that at least for boys of his age, which would be 8 years 8 months, at least 39% of the boys would weigh less. For a BMI of 56, it would mean for his age, that time, which was in December of 2021, that at least 55% of the boys would have a BMI of less than 56. That clearly, by the definition of the Center for Disease Control, means that BMI was completely normal. In fact, right smack in the middle.
What does that tell you
Well,
about,
there
I mean,
you
is there
go.
any evidence of malnourishment in the record?
No, there is not. By the records that I reviewed, his most recent BMI of 56.
Well, I'm just I'm
um,
underly
he has
tall
a,
for my BMI.
weight at that time of about 113 pounds, 4 ounces. In order to be judged to be not of a healthy weight, he would have to lose over 18% of his weight. So he's well outside the guidelines for being underweight.
Well,
And is it
Bobby,
fair to
if
say
you're
that
tall,
there's no evidence in the
you're-
record that he wasn't being fed?
you're never going to win with that one.
Sustain, rephrase, and it's more, with a more specific period.
In the records that you viewed from 2016 to 2019, you said there's no evidence of malnourishment, correct?
Yes, I said there is
Oh,
no
Lord.
evidence of malnourishment as judged by the BMI charts. For the question that you just alluded to, when people are deprived of food, they lose weight, and that mathematically causes their BMI to decrease so that then it is no longer within normal range.
And based on the records that you reviewed, which again are from 2016 to 2019, is regularly being taken to the pediatrician.
Yes, although the records actually, I think, extend to 2021.
Thank you. No further questions.
All right, any cross? All right, is this witness excused, Ms. Morat? All right, sir, that concludes your testimony. Thank you. You may step down. Have a good weekend. Okay.
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 One
All right,
second.
so
Let me get my audio to work and then might have to break out the gamer headphones. We can always go.
ladies and gentlemen, that means that we're going to conclude the proceedings for today.
Are you guys wanting to look at the Natalie Holloway press conference, or do you want to stick with this? I feel bad because we are trying to trudge through this trial and I want to get it done, but I also have ADHD and I'm bored of this trial. So given any opportunity to ditch this trial, I will ditch this trial, and I don't want to be a bad influence on anyone trying to finish this trial. So I will let chat choose because I am not a good stay on tasker person. All right, I will look for the Natalie Holloway press conference. My guess is that it will be front and center. Is it currently live or was that 45 minutes ago? Because I'm not seeing a live one right now. I'm seeing from 1 day ago. Well, here, let me pull this over, stop screen, present. I can share what this Court TV has for this.
Though we do have an update in the Natalie Holloway case. Jorn Vandersloot, the chief suspect in Holloway's disappearance back in 2005, is expected to now plead guilty to trying to extort money from Holloway's mother.
All right,
Vandersloot was recently extradited to Alabama to face the extradition charges. His sentence is scheduled for October 18th. Vandersloot is serving a 28-year sentence in Peru after admitting to killing a woman there in 2010.
That's right. We know Natalie Holloway. I remember watching this. She vanished in 2005. While on the high school graduation trip to Aruba, she was last seen leaving a bar with Vandersloot at that time. And Court TV's Kelly Craft gives us a look back at Vandersloot's past.
Here we go.
It has been 18 years since Natalie Holloway vanished while on a senior trip in Aruba, and 13 years since Stephanie Flores was murdered in Peru. Joran Vandersloot has been the #1 suspect in Natalie's disappearance, and he confessed to beating Stephanie Flores to death. Cole Thompson, a former Court TV senior producer, co-authored a book called A Portrait of a Monster. It profiles Joran Vandersloot and the many twists and turns in this case.
In 2005, Natalie disappeared. I was working for Court TV. I was working with Catherine Cryer. It was just one of those huge stories that captured the everybody's attention. It was like OJ or John Benet Ramsey or Scott Peterson. 5 years to the day, almost the same thing happens again in Peru. And I just got incredibly lucky. Just
All right, it looks like they're setting it up.
Wound up
I've
being
got
introduced to
Inside
the actual
Edition.
investigative team, the Red Ball team that was handling the homicide. And for some reason, they just took a liking to me.
In 2010, Vandersloot was in Peru where he met Stephanie Flores. But to get to Peru, he needed money. He got that money by allegedly extorting Beth Holloway, claiming
What
he would
a
take her to
douche.
show her daughter's remains for $250,000.
He approached the Holloways. He asked for this money. Now he's screaming entrapment. But
I hate, like, sir, you went, yeah, Vanderdouche is such a douche. Oh no, you're fine. You are fine. I am not going to claim to be a good person with staying on task, and swear to goodness, the Boy in the Box trial is like my, the kid that still has to do the 50 lines and they're down to the 10, and you have to get it done, but you're just like, oh my gosh, if I just get it done, I can get done with it. But it's like that last, yeah, I'm gonna have to chop it up, but there's other streamers that are also doing it, but I don't want to snipe from them, so I'm trying to.
But he used this money to fund his trip to Peru, where
I'm
another
looking
girl
through.
died. If he hadn't had this money, he would have been stuck in Aruba. This must weigh heavily on everybody involved.
Thompson was embedded with authorities in Peru. In the book, lead homicide investigator Captain Juan Callis Vargas tells Thompson this about the death of Stephanie Flores. The beating was overkill, savage, and the level of violence indicated that he had probably done this before. The level of violence had likely escalated over the years. Callan also described Joran as cold and calculated.
It looks
Callan
like they're walking
recognized
out
that he was in
now,
the presence
so I'll
of pure evil.
He came
keep
from
an
a
eye
fairly
on it.
normal family, seemed like a child of privilege. Very early on, they figured that something was the matter with Joran, that he was potentially a monster. He beat one of his brothers nearly to death.
Thompson shared with us surveillance photos from the night in Peru when Vandersloot killed Flores. You can see Vandersloot and Flores entering the hotel. Then Vandersloot exits alone. He also shared with us crime scene photos, an
Good
investigator's
Lord.
sketch of the crime scene, and Stephanie Flores' grave. A sad reminder that two young women who never met are so eerily connected.
Two families sitting there watching surveillance tape from a casino of their daughters
And I mean,
and this man.
how sad. I mean, he's a tall guy. He was probably chatting them up. And, you never think, okay, this person I've just met could be dangerous. I always tell my girls, if you ever get that icky feeling, do not ignore that icky feeling. If you get that icky feeling, I don't care if it's 4 a.m. in the morning. I don't care if it's, 1 p.m. at night, call me and I will come get you. I mean, I may be irritated, but
the only suspect.
I'd rather be
in either
irritated
case.
and called out of bed than you ignoring icky feelings.
Let's bring in criminal defense attorney and former prosecutor Marie Pereira. Marie, you're in New York there. This is a case that, I remember being glued to the television when she disappeared. And I may be biased, but I think he got away with that murder. And to plead guilty now to at least some sort of relation to the Natalee Holloway case, the extortion charges. How do you think that moves the ball forward? Do you think this will definitely help the family, at least a step in the right direction to some sort of justice?
It is a step in the right direction because you know what they say, justice delayed is not justice denied. I feel that this extortion plea is incomplete justice, but it's something. And it doesn't really bar any murder charges should they have enough evidence to charge him with murder, because there's no statute of limitation on murder. So for now, at least it's something for him to admit what he did, the grief he put on that family, the lies he told to them, and the just heinous nature of him just trying to extort the mother and father like that. And all they wanted was just to really just find the body and put
It's
their
okay.
child
I have
to
scrolls
rest and
on
give
my
her a
own.
proper burial. It's something, but it's incomplete justice in my eyes.
Yeah, from his standpoint, though, why plead guilty unless he wants to go back to Peru, where he undoubtedly has a little life in the prison there, and they want him back. You hear these stories, a Peruvian jail must be horrible. But on the other hand, I don't know that hanging out in the Alabama prison system is going to be much better for him. And this may be calculated on his part, given what we know about him. And I just can't see him at this point saying, I want to do the right thing.
Okay, stop. All right, they've come out. Let me go back to where I was hearing talking in my head and I thought I was having a stroke, but no, they started the press conference. So let me go to the press conference. I am not having a stroke. We're all excited. So let's go to the press conference. And they will be coming. We're a little bit behind. And we will just keep my banners on. And I am going to All right, so this is the family, and I'm guessing the attorneys. Again, since this is a federal case, there were not cameras allowed inside the courtroom. No federal cases are televised, though I think that is distinctly unfair. I do believe that federal cases should be televised just like regular cases. Well, I'm glad the mom at least finally learned what happened to her daughter. And for the love of God, woman, you have 973 mics and still a lawyer cannot get in front of a damned mic.
Good morning. Thank you all for being here with us this morning. My name is Prim Escalona, and I'm the United States Attorney for the Northern District of Alabama. I'm going to make a brief prepared statement, and then I believe that Beth Holloway will also be making a statement. Today marks the end of 18 years of wondering what happened to Natalee Holloway. Now, Beth and Dave can rest, and Natalee can rest, knowing that justice was served. For the Holloway family, this has been a journey filled with patience, perseverance, and courage as they continued to seek justice for Natalee. I hope today will give them peace. I want to extend my deepest appreciation to the FBI, the Department of Justice's Office of International Affairs, the governments of Peru, the Netherlands, and Aruba, the United States Marshals Service, and the Shelby County Sheriff's Office for their efforts that helped make today possible. I also want to recognize from my office, Lloyd Peoples, Catherine Crosby, and Tanya Benninger, who worked tirelessly over the last year and a half on this case, along with many others in my office who have worked towards justice for the last 13 years. Also, I want to thank the court and the federal public defender and his team for their diligence and professionalism throughout this prosecution. Ensuring a successful prosecution took a great amount of collaboration, and I'm grateful for all of the hard work and dedication that has been devoted to this case. The world watched in 2005 as Beth and Dave Holloway experienced every parent's worst nightmare. As a mother, I cannot imagine the heartache, the sleepless nights, and the tears that Beth and her family must have.
And I remember this. It was about, 3 years after I graduated high school, and I remember just thinking, you know, about all the dumb things I did, all the, stupid decisions I put myself in, and, all the I was safe, all the gentlemen, the boys that I was around, chose to be gentlemen, chose the right things. But, if one of them had been a monster, if one of them had been Jordan, I mean, just how many unsafe choices I made, in those dumb years. Eh, by the grace of God, I swear, half of the things I did as a child.
Have shed of wondering what happened to Natalie. Despite their grief, the Holloway family kept fighting for justice for Natalie. Their love for their daughter and sister is what brought us to this day. For Beth and Dave and Matt, I hope today is not just about this sentence. I hope it's about healing, about finding peace, knowing they did everything they could for their daughter and their sister. I hope today will help all of us move forward, not in sadness, but in celebration of the incredible life that Natalie lived. Beth, may her memory be a blessing.
Thank you. Thank you so much.
Okay, y'all, I'm not crying, you're not crying.
Well, today I can tell you with certainty that after 18 years, Natalie's case is solved. As far as I'm concerned, it's over. It's over. Joran Vandersloot is no longer the suspect in my daughter's murder. He is the killer. In the course of his felony prosecution, here for extortion and wire fraud indictment, he gave a proffer in which he finally confessed that he killed Natalie. He described when and how he killed her. He said that after killing her on the beach in Aruba, he put her into the water, and that was the last that he ever saw her. That was all verified by a comprehensive and conclusive polygraph test. Even with this confession, though, he can't be tried here for Natalie's murder. But I'm satisfied knowing that he did it. He did it alone, and he disposed of her alone. I won't give you the details of his brutal confession. Those will be forthcoming when the proffer is made public. You will also have details of the plea agreement which was reached. His sentence of the extortion and the wire fraud will run concurrently with a sentence in Peru for killing Stephanie Flores. And that's fine with me. Thanks to a lot of very smart and dedicated people here, I got the answer I've been searching for the past 18 years. Joran Vandersloot's confession means we have finally reached the end of our never-ending nightmare. And for me, reaching the end of the nightmare, being over, is better than closure. It's been 18 years since Natalie disappeared, and Natalie would be 36 years old today.
Oh my
I
gosh.
still miss her every day. It's been a very long and painful journey,
but we finally got the answers we've been searching for all these years. We finally, today, we got justice for Natalie. So thank you all so very much and being supportive of us in our long 18-year journey. Thank you.
By the way, inside you said you looked at your son and said, we did it. How do you sleep tonight? As a mother, as what she has today.
Yeah, I think we sleep well. I mean, this has been the most unimaginable journey, and I know everyone has been with us on this, and we are so appreciative of it. But for us to finally put this to rest and being over, as I said, it's better than closure because our never-ending nightmare had to end. And we are so grateful that we can say that today, that it is over. And that is getting justice for Natalie.
He said from the podium, he's a changed man.
I don't. I just know that there are no charges that will be here for his murder, but hopefully maybe they will look into that. Do you need that or just have what you need? No, I have what I need, but I have what I need.
Did you believe when he said that he's a changed man?
I definitely don't. I don't believe he's a changed man at all.
How did it feel to see him in the courtroom? It feels victorious. I feel like you finally begin to transition from the victim to the victor, and it begins to make the pain and suffering feel somewhat less intense because you are here. You are at this point, the pinnacle of the journey, and you've gotten justice and you've gotten the answers you've been so desperately seeking. So it felt victorious. Are you confident the justice is out of him? Oh, I'm absolutely confident. Yes. Yes.
Have you had the opportunity to talk to Yoram in the courtroom? What did you tell him?
I was able to tell Yaron that I think in this long ending.
Well, I have misspelt his name because I've been adding a D to his, but apparently his name is Yaron instead of Jordan. But, and this woman is classy AF, which I know should not end that sentence. So they did a comprehensive polygraph, and I think they corroborated with other information that they had pieced together. But this woman is classy. She is, I would say, butter would not melt. She is just cool. She is calm. I want to be her when I grow up. I mean, I could not imagine going through what she's gone through, and to have the classiness, to be put together, to handle this with such grace. And I know this is the public facing. I'm sure there have been, the breakdown, crying in the shower, moments. But to do all of this for her daughter is just 18 years of waiting to find out the truth. My hat off to her.
Nightmare. Able to express things to him that I had been wanting to tell him, as far as telling him who he is, and he is a killer. He is a killer. He will always be the killer. He will always be now the black mark in Aruba. He's now confessed to 2 murders. So that was good for me to be able to tell him that and to share that.
Do you hope that Aruba maybe reopen the case?
I don't know about that, but I'm just sticking with victorious right now. Thank you.
Can you tell us a little bit about, in the courtroom, they said that you sat as he was explaining what happened. How was that?
It is shocking, and it is horrific to hear a killer that describing the brutal things that he did to my daughter, Matt's sister. It's shocking, and it is very disturbing. But it's things that parents have to know the truth. They have to hear the answers as to what happened in order to put this to rest and for it to be over.
Look, the things that go on in your mind are so much worse than the truth, I think. I mean, I'm sure for 18 years she has imagined every single horrific scenario and possibly even imagined that Natalie's still alive, being trafficked somewhere, possibly, living in hell still. So I can only imagine that while it is horrific and horrifying and downright soul killing to hear what her child went through, it kills every single one of those nightmare scenarios. That one nightmare kills every single one of these horrible nightmares that she's been living with because it's been a blank slate. Now, why journalists have to ask ridiculous questions like that, because more normal people know the answers.
Vandersloot let you guys know others are involved. He acted alone. Yes, he acted alone. Thank you all so much.
Tell us about Natalie. Tell us about the 18 years before.
Natalie was very bright, very smart, dedicated young lady. She was on her way to college. She was headed to medical school after that, and I have no doubt she would have made it all the way. So we love her. We miss her very much. And we wake up every morning with thoughts of Natalie, but now we wake up knowing that we have reached justice for Natalie. So
She
thank
was
you.
truly the best sister I could have ever asked for. Absolutely.
Have you said a full and complete goodbye to Natalie at this point? Have you visited with her in your own way and let her know that you have peace with all of this?
I don't really look at it as saying goodbye to Natalie, because we wake up every morning and the hope that filled her life and heart fills ours today. So I feel like we carry Natalie with us even forward now, and that's a very good feeling. It, like I said, it feels victorious. But thank you so much. Thank you.
Thank you, everybody.
Oh, yeah, I'm glad they didn't let the press keep her too long.
Dave Holloway, as you heard in the proceedings, submitted a written impact statement to the judge, and we are releasing right now a statement that he is submitting in lieu of answering questions on this incredible day. If you need to give me your contact information, they can send you that statement along with his letter, which is attached to the statement. Just contact me myself or my law partner, Kitty Brown. We'll be happy to get that to you. Thank you very much. The number that you can call, if you can text and send your email, is 205 960.
All right, let me see if anyone else comes out. No, I guess not. Okay, so that's all we have there. I guess we will wait for those papers to come out, the pleadings and filings and everything, and then we will probably have a stream where I will go over those particular that information. But we are back and we are going with yeah, no problem. No, I definitely wanted to go over it, and I misspelled his name, which honestly, who cares? Now I'm going to go ahead and say one-time convicted murderer in Peru and pretty much convicted-ish murderer in America. So, it is what it is, Mr. Not Jordan Urine Vandersloot. I think I might have just done a
As I've already given you the heads up, we'll start back on Tuesday. We're going to start at 9 o'clock sharp
all right.
on Tuesday.
So let me actually stop this screen and get you day number 5. We are going to plow through this trial. I swear to goodness, we're going to get done with this trial at some point. It will happen. So at this point, the defense has pointed out, according to their expert pathologist, that the child is not underweight. That the child has not been okay. So it is on 1.25 speed. We do have the closed captions.
It'd be the psychiatrist.
That the yeah, I'm kind of there with it. But that according to an expert pathologist, that the child was not underweight at the time of excuse me, at the time of the crime or that December. So according to BMI, as nefarious of a measurement as that is, the defense at least has proven that he was not underweight. For the most part, I think they did a good job proving that. I don't know that any of their other witnesses really did anything for me. And I think that Lucy and Bobby are correct. I think that the parents should have focused more on the things that they did to try to deal with the behavior as far as taking Ronan to therapist, things like that, not attacked the child's behavior, but how they tried to improve and or deal with their behavior on the parents' side. Not so much the child's behavior, making him the bad guy, but how they were reacting badly, obviously. But, they were trying to be proactive. They were trying to provide help, and they were doing it badly, but they were trying to do good. They were doing something.
Psychiatrist, is that?
The psychiatrist is Dr. Rappa. She actually got caught in an accident on Southern and is going to, her ETA is parking at 9:05. So if the court does want to wait for Ms. Coakley, it might be a little easier to just go straight through.
I'm not going to wait. The only thing I wanted to address is my understanding from last week is that there was a motion that the state was making in regard to additional opinion.
I advise Ms. Coakley I will not be pursuing that opinion, but I don't want to speak on her behalf, so I'm happy to wait.
All right, so nothing for the court to decide?
I don't believe so, but I don't want to misrepresent what Ms. Coakley would like.
Ms. Black, are you prepared to respond? And if she's on her way, I can wait a few minutes. Yeah, why don't you check? It's not the biggest deal in the world. This has gone on a while as it is, so another minute's not going to make any difference. Ms. Coakley, I was just raising with Ms. Murad the state's motion, or at least I thought you indicated you were going to file a motion in regard to additional opinions that the defense was attempting to introduce via Dr. Rappa's testimony. Ms. Murad has indicated that she's not pursuing that anymore, so I just need to confirm that there's nothing for the court to decide in regard to that. Is that accurate? Okay, all right, good enough then. All right, so you want to call your next witness, and then we'll see. All right, and so just for planning purposes, give me a little bit of idea of what we're looking at today. I'm assuming this witness up front, Dr. Rappa, and then do you have any other witnesses besides the possibility of your client testifying this? Okay. It's been admitted into evidence already, or it's going to be part of it? 14 hours? All right. Do you know how much you do intend to play? Okay. All right. Yeah, I only asked not to infringe at all upon your defense, but only to get an idea as to what we're looking at in terms of logistics. Yeah. The same type video that we've seen already? Okay. All right.
Yeah,
Okay.
there may be objections, Your Honor. I was provided a list of what they intended to offer about probably 9:30 last night. Earlier, I was provided a list with 3,000 videos that was approximately 50 hours long. I started to go through that, but now it's my understanding that's no longer what they intend. And so I haven't had a chance to look at what they offer. That larger list did have things that the state would object to. Okay. So just to let you, Your Honor, know, I haven't had a chance to look at this 14-hour video that they now have indicated they're going to enter.
So I'll address that when and if you raise it. So it sounds to me like, Ms. Murad, a reasonable shot of you resting today. Is it? All right. And are you going to make the decision as to whether your client's going to testify before or after you publish the videos?
I don't have an answer to that, but I suspect we will know a little bit more during the lunch hour.
Okay.
And depending on the court's rulings, that'll sort of.
Okay. All right. Good enough then. All right. I think we've addressed all the pre-trial issues that I needed to address this morning. Anything else we need to address before we bring the jurors in? Use the mic, Mr. Sooner than later, we'll probably try to do it during the first break. not the first break, but when we break for lunch, we'll spend a few minutes on that. Are there some issues on the jury instructions that I'm going to need to work through? You need to have a microphone.
So for the parental defense, it's our position that that the burden of persuasion, that once we present it, just like a self-defense, it is upon the state's burden to unprove it or to disprove. And just like self-defense.
Is there a standard that addresses that? Because I really don't intend to depart from the standard if there's a standard.
Yeah. So the jury instruction actually.
Well, here's what we're going to do. I just wanted to know if there's an issue. I will address it then when I bring up the instructions for consideration. We'll probably do that at the lunch hour and take whatever time is necessary to do it then. But and then just be prepared to tell me if there's a standard instruction at that time, and then I'll hear argument on everything. All right. So, Ms. Murad, are you ready to call your next witness in? All right, you may do so. Let's go ahead and bring the jury out now.
I really, really, really hate the little blouses with the bow ties. I don't know why I have. It's like my irrational hate of the song Red, Red Wine. I don't know why I hate it.
All right.
It's not rational. It's not kind. But I have a violent reaction to it.
All right, everyone may be seated. All right, ladies and gentlemen of the jury, welcome back. I hope everyone had a good restful relaxation for the long holiday. I hope it was a long holiday for all of you. It was for the court. So with that being said, we are still in the defense portion of the case at this point. And with that, Ms. Murad, are you ready to call your first witness?
Yes, Your Honor.
Okay.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
And Ms. Murad, you may begin at your convenience.
Thank you, Your Honor. Good morning, Agent Lowe. I know you've been here before, so I don't want to belabor your background, but could you restate your name for the record, please?
Yes, I am Christopher Lowe with Jupiter Police Department.
And in this particular case, you received a Dropbox link of the Ring camera videos from Ring. Is that correct?
That's correct.
I just wanted to clarify a few things for the jury regarding that Ring camera.
Yes.
So it's my understanding that
The
some of the
UB
videos from the living
version.
room are missing. Is that correct?
I cannot confirm that there's any missing videos.
Okay. We don't have any videos after January 9th of videos from the living room, correct?
Within the folder, I'm going to notate the
Go ahead.
name. Folder 24738902, which is a depiction of the living room. The files encompass January 5th through January 9th.
Okay. And of course, the jury has seen videos from January 5th all the way to January 28th. So it's fair to say that from January 10th to January 28th, there are no videos from the living room, correct?
As provided by Ring, correct.
Have you had an opportunity to view at least one of those cameras from the Ring camera that was placed in the living room?
Yes.
Okay. So when you look out into that camera, you see the living room in front, correct?
Correct.
It's kind of like behind a TV, it seems.
It's in a corner.
Okay. So in front of it is like a sofa. Is that fair to say?
Yes.
And then the kitchen is behind it, correct?
Yes.
And then sort of off to the right, you see the dining room table.
Okay. I can agree to the sofa, the kitchen.
Okay. And do you recall if you can also see the dining room table from that angle?
I don't recall that portion.
Okay. Is it fair to say that no other Ring camera angle shows you the living room, kitchen, and dining room table other than that one?
Of what I observed, that's correct.
I also want to talk about, because the state played a lengthy video with the epoch time and UTC time. Could you explain again to this jury? So my understanding is that the file names provided in that Dropbox are, for the most part, a series of numbers. Is that right?
That's correct.
And those series of numbers are indicative of something called epoch time.
Yes.
And could you explain to the jury again how you get from that file name to the date and time?
All right. So in regards to the Unix epoch time that I had previously spoken about, that number itself is a unit of time starting from January 1st, 1970, and it can be notated in seconds or milliseconds. And you can take that number, place it into just a simple converter online, and it'll produce the UTC time, which you can then convert to the Eastern Standard Time.
Understood. So the video that the jury saw, there was a montage of sort of a number of videos from inside of Ronan's room. Those are in UTC time. What is the difference between UTC time and Eastern time?
So for the time in which we're concerned, being in January, it would be a difference of 5 hours for Eastern Standard Time.
So if something is, let's say, 4:35 p.m. UTC, what is it in Eastern time?
It would be 11:30.
So if Ronan's getting into bed at 4:30 UTC time, that's actually 5 hours later. Or I'm sorry, 5 hours earlier.
Earlier. Yes.
Okay, I'm sorry. So the Eastern time is earlier.
Yes.
Okay, understood. So the bed example was not a great one. Prior to this, did I give you an example of a file number in this case to convert into UTC time and Eastern time?
Yes.
Okay. And was that file number 164-138-414-4000?
Yes, that's correct.
So how do we get from that to the UTC time and then to the Eastern?
So simply placing that number into the converter, as I mentioned, it produced a UTC time of 12:02 and 24 seconds PM. Then you just subtract you subtract 5 hours to get to 7:02 and 24 seconds.
Are there also file numbers that are not in epoch time?
Yes.
And those file numbers, I believe, start with like 70505.
Generally, yes, that's correct.
What unit of measurement are they in?
That's unknown to me.
Okay. And are those file numbers also indicative of a time and date?
Are those file numbers?
Mhm.
Not that I know of.
Okay. Is there a process by which you can determine the time and date from those file numbers?
Yes.
What is that process?
So as I previously mentioned, there are 11 subfolders within that return from Ring. Okay. Within 6 of those subfolders, there's an individual file in each one. When that file is converted into an Excel format, it produces a timestamp associated with the files that begin in the 705. So a simple conversion into an Excel file provides the timestamps necessary to associate.
Thank you. All the videos that you were provided from Ring in that Dropbox are, for the most part, I know there's some that aren't, in 60-second intervals, correct?
For the most part.
And it's fair to say that there's no video of sort of 24-hour monitoring of what's going on in the home. It's just sort of those 60-second spurts that we all have to piece together when there's movement.
Correct.
Do you know why from January 10th to January 28th, there are no videos of that living room Ring camera?
I do not.
Okay. And are you just relying on what Ring provided to you?
That's correct.
But it is fair to say that the living room camera prior to that did exist, right?
Correct. From what I received January 5th to the 9th.
And there's no video on the 9th, 8th, 7th, 6th of the Ferreters taking that down that you're aware of?
I did not review that camera in that specificity. I didn't review each
Okay.
of those videos. No.
Understood. No further questions for this
All right, any cross, Ms. Coakley?
You don't know why there isn't additional videos, right?
Correct.
They could have turned off the camera, right?
There could be a number of reasons. Correct.
Then that's one of them, right? They could have turned it off, correct?
Correct.
They could have unplugged it.
That's possible.
Yeah. They could have, it could have just broken, correct?
Yes.
That's all the questions I have.
All right, any redirect?
Since it's movement activated, if they did come in and turn off the camera or take it out, you would suspect to see movement there, right?
Overruled.
That's possible to capture that video.
Okay. And in this particular case, Ms. Coakley gave you a number of options of it could have been this, it could have been that. It's fair to say you have no idea. You just have what you have from Ring.
Correct.
So you have no ability to say that the Ferreters turned that off, correct?
Correct.
And in fact, they didn't turn off any of the video in their son's own room, right? During that time period. There's no evidence of that.
I cannot determine whether or not a camera is turned off.
Okay. Thank you.
Thank you, Ms. Marad. Is this witness now excused?
Yes, Your Honor.
All right, sir, that concludes your testimony and you're excused from further proceedings in this matter. Thank you.
Thank you.
All right, Ms. Marad, I'll call you next witness, please.
Dr. Sheila Rappa.
And you're doing the direct, Ms. Marad?
Yes, ma'am.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, Ms. Marad, you may begin at your convenience.
Thank you, Judge. Good morning.
Good morning.
Could you introduce yourself to us, please?
Sure. My name is Sheila Rappa.
Dr. Rappa, what do you do for work?
I'm a clinical and forensic psychologist.
I want to start with
How do you
your sort of
spell your
experience.
name?
Can you take us through your educational experience to become a clinical and forensic psychologist?
Yes. So I received a bachelor's degree in psychology in the year 1990. I went on to get my master's at Obizu University in 1994, and then I completed my doctorate in 1999, also at Obizu University. I did my internship at Miami Children's Hospital. I did the inpatient and the outpatient unit, and I did my residency at Atlantic Shores Hospital. I was licensed in Florida at the year 2000.
When you talk about some of your sort of work experience, can you take us through specifically the experience that you've had working with children with severe sort of behavioral issues?
Sure. My first introduction to children with severe trauma or severe behavioral issues was right after I got my master's degree. I had to do clinical hours, and I did them at a place called Kids in Distress that is in Fort Lauderdale. At Kids in Distress, it's a not-for-profit, but they take in all types of children, normally children that have been removed from
Wait.
their homes due to
So there are facilities that take children who are acting out where you could go and say if you had a problem child, seek, and I'm guessing they advertise on the Google machine, is what you're telling me.
to severe neglect or any kind of childhood trauma. So Kids in Distress would have any children from birth, all the way up. The ones I worked with were probably up to the age of 13 at that time. So I did that for my clinical hours, and then they hired me. So I started working there, and I worked a lot with children at that facility that were just severely traumatized, had diagnosis of reactive attachment disorder, had diagnoses of PTSD, just different types of childhood disorders. When I did my internship, or when I chose what internship I wanted to do, I really did want to focus on children, and I wanted to focus on victims. So Miami Children's Hospital was available to me, and that's one of the places that I applied to do my internship and was accepted. Miami Children's Hospital at that time had an outpatient unit, and they also had a locked residential unit. So I not only saw the children that were on the outpatient unit and did therapy with family and children, a lot of trauma. Also, there were the children that were on the inpatient unit that were actually locked inside the psychiatric facility because they were a harm to themselves or others. After I finished my internship, I quickly, within probably a year, started working at Chrysalis Health. Chrysalis Health is a community mental health center, serves about 3,000 clients a week, so very busy mental health center. Best known in the community for working with trauma and children and adolescents that are exhibiting behavioral problems, PTSD, any type of diagnosis pretty much that you can imagine. When I started at Chrysalis, I started just doing therapy, doing assessments. And then as I continued to work at Chrysalis, I became the clinical director. And right before I left Chrysalis, within like 3 or 4 years, I was their chief clinical officer. That meant I had to oversee probably 200, maybe 250 therapists that were doing the work in the families, in the homes, with the children, with the traumatized individuals. I also had to do the clinical programming for our group homes. We had residential homes, which were group homes for adolescents that had kind of failed out of the foster care system. Nobody would take them, so they put them into our group homes. Severe behavioral disturbances, a lot of trauma there. And I oversaw all their clinical work for that. And then pretty much after that, I just continued with my private practice. I started a private practice quickly after I got licensed. And, worked at Chrysalis, also did a little bit in my private practice, but eventually the private practice kind of took over. And now I'm in private practice full time, and I only do forensic work. No more clinical work for me.
How long in your career did you do clinical work? So when did you go full time into the forensic?
I did clinical work from 1995, probably until 2010, maybe.
So pretty recent.
Yeah.
That was your consistent practice, was doing clinical work. Is that fair to say?
It was. I really, really love the clinical work. I like being in the gutter kind of with the families and helping them figure things out, and with children. My practice just got too busy and I couldn't do clinical work. I couldn't maintain the consistency anymore.
What experience do you have working with parents of children who have sort of early life trauma and severe behavioral issues?
Most of the parents that I have worked with that if you're going to talk about really significant trauma or really significant abuse, the parents that I would most likely work with would be foster parents or adoptive parents. There's not a whole lot of biological parents that I had to work with where their children were very severe.
So this is actually a good expert to have for the families had they gone to this doctor and sought help and were still having issues. But this is about the expert that they should have had to go with this particular, again, had they maybe taken some more affirmative action to get him help instead of reacting their case, I think, would have been better.
Severely abused or neglected, although there have been some. But most of it is foster care people that get their foster care parents that get these children and don't know what to do, or adoptive parents that get these children and they really just don't know what to do.
Now, your doctorate is a PsyD, so you're a psychologist, correct?
Correct.
This jury heard from the state's expert, Wade Myers, who is a psychiatrist. Can you explain to us the difference between psychology and psychiatry?
Sure. So psychiatrists are medical doctors. They actually go to medical school, just like your PCP would have gone to. They go to medical school. And then after medical school, they decide that they're going to specialize in psychiatry. And so they do rotations and get training specifically in psychiatry. Psychiatrists are probably best known for giving medication. So they do a lot of medication management. They know what types of medication to give for what type of psychological disorder. And really, some psychiatrists do some therapy, but most psychiatrists really deal with medication and medication management. Psychologists are a PhD. Mine is a PsyD because I'm a doctor of psychology, but it's easier to understand as a PhD. So it's a doctorate that you earn, and you have to have your bachelor's in some sort of human behavior study. Then you would get your master's in psychology and then your doctorate in psychology. So you're studying human behavior throughout. And really, if you include your internship and your residency, getting your doctorate takes about 12 years. It took me about 12 years.
As a psychologist, assuming that you actually evaluate a patient, are you able to come to a diagnosis in the same way that a psychiatrist is?
We do the same things, except the psychologists will do psychological testing. Normally, psychiatrists do not do psychological testing. They might do screeners to kind of assess and see where they're at in terms of diagnosis. But psychologists do psychological testing. Other than that, pretty much we arrive to a diagnosis the same way.
In general, and we'll talk more specifically briefly, but sort of in general, what is psychological testing?
Psychological testing can encompass many different things. It can be educational testing. We want to see someone's IQ. We want to see their achievement, how they're doing in school. It can also be leaned toward figuring out if someone has a psychological disorder. Does somebody have depression or anxiety? Are they bipolar? Are they schizophrenic? Testing will help with that. It can also tell us personality makeup. How does this person function in the world around other people and function in general? So it really depends on your referral question, what types of testing that you're going to be doing, but there's a plethora of tests that we can give for all different types of things.
Those tests that you give, are they standardized and accepted in the community as being able to render, I guess, data that helps you determine those different things that you were talking about, like IQ? So if you're giving a test and some other psychologist is giving a test for the same thing, is it going to be the same test?
Yes. So the tests are standardized. The tests also have validity scales to make sure that you're not only giving the test reliably in the right way, but the test taker is taking them in a valid way. So these tests are more objective measures. It's not just somebody sitting back and looking at a case and then giving a diagnosis, but the testing really helps solidify that diagnosis.
I want to turn our attention to this specific case now. So you were hired by my law firm in this case, is that correct?
Yes.
And you're being paid for your time at an hourly rate, is that correct?
That's correct.
Is that common in your field?
Yes.
Okay. Are experts normally reviewing materials and coming to court for free?
No.
Okay. I want to go through what you reviewed in this case. Can you take the jury through that?
Sure, I can. I had to make a list because there's a lot. All right, so here are the records that I reviewed in this case. I had his early childhood records. I had photos of him as a child.
Fry,
and he
stop
had
showing your
babies on
bits
his
and
body.
pieces. Where did you get
Sustained,
another shoe?
I've seen your objection as she's testifying from the page in front of her.
Freiberg.
Yep.
Fry. This is yours. This, thank you. You're not supposed to have this shoe. I don't know how you keep getting shoes, but you aren't supposed to have shoes. Look, this is Fry's bucket of toys. Fry has all sorts of toys. Fry doesn't get shoes.
Fry has sticks. Well, if you want me to play with you, you have to bring it over here. Do you want head pats? No biting. Just head pats. No biting. No, you don't need cashews, you ding dong. we'll probably go for another hour, and then I need to take Mr. Freiber on a walk. We're working on walking for both of us, getting our steps in. Here, let's say hi to the peoples. Say hi to the peoples. Oh, you're getting too big to be a lapdog. And too ornery. Too big and too ornery. Oh, not twice.
All right, Ms. Murad, you may proceed.
Thank you.
All
Dr. Rapp, you
right,
can continue.
go get your
listening.
toys. You have fry toys.
The Department of State medical records, records from the Family Care International Clinic, and records from a Vietnam doctor. I had records from Family Counseling Associate, from Kathleen Martin, from 2015 and 2016. I had records from Dr. Rickenbacher from 2019.
No, Sirbert.
Medical records from other providers, 2019 to 2013. Then I had more from 2014, 2017, and more from 2021. I had school records from Immaculate Heart Academy, and there were emails in there between the Ferreters and the school staff. I also had his school records from Basis Academy, and again, emails between the Ferreters and school staff. An April 2022 clinical summary by Kenny Miller, who diagnosed him with reactive attachment disorder. I also had his non-psychiatric medical records from 2009, 2021. I had a memorandum. It was created either by the mom or the dad, I'm not sure who, detailing the efforts that they took to get Ronan help from 2012 all the way up to 2022. I had a photo of a fractured shoulder from.
Sustained. You can state what you receive, but you can't go into the details of what that document was.
Okay.
You may continue.
A neuropsych testing. I had an incident report from
Oh.
Devereaux Behavioral Health from 2022.
Yeah, it's always
I had Baker Act.
it's always my Birkenstocks too. I have a special type of Birkenstocks that don't bother my feet, and I can pretty much wear those and Crocs and maybe a couple pairs of Uggs, and those are the shoes that my feet will tolerate, or my leg. And it is always those doggone Birkenstocks that he just wants to bite the heck out of. And I think it's because it's real leather. So I can understand, but sir, those are, I mean, it damn near killed me because I'm a cheap person. I am all of the cheap. And to have to buy $100 pair of Birkenstocks nearly killed me. So yeah, Mr. Fry does not get to bite the Birkenstocks.
Track records from JFK and Central Behavioral Health in spring and summer of 2022. Emails between former foster parents and ChildNet. Interview
Did you
transcripts
find lamb
of
chop?
Alan Anderson, Kellen McCoy, and Steve Johnson. I had the CPT interviews I had both the videos and the transcripts. I had no deposition in this case, also the
Bring me
transcript
lamb
and
chop.
the video. Deposition in this case, the transcript and the video. Interview with Detective Sharp, the transcript and the video.
Ding dong. Lamb chop.
Documents produced by a state expert. And I also watched several hours of Ring video, both the Ring video inside the room and outside the room in the home. I had the same packet that was sent to the state expert, Dr. Myers, and I had the deposition and trial testimony of Dr. Myers and the trial testimony of.
Thank you very much. So I want to talk about also what you could not review. Were you able to evaluate in this case?
No.
And was a request made for that?
Yes.
Sustained. Jury is instructed to disregard the last answer in question. You may continue, Ms. Moran.
Understood. It's fair to say that you were not, well.
I do not understand why they did not let them interview the child, but I guess that goes to, again, the child is not the person on trial. So I guess she could have, in theory, done testing on Timothy, but not on the child, I guess. I don't know. I'll have to ask David when I talk to him next about this case to see if that maybe was the reason that neither of the experts, evaluated the child.
I will let that go. So you had an opportunity to review Wade Myers's trial testimony, correct?
Yes.
So I want to sort of start with your opinions regarding the Ferreter's actions. So
No.
do you have an opinion as to whether the Ferreter's actions were therapeutically correct?
Yes.
What's that opinion?
I think the Ferreter's actions were against anything that we would ever tell someone to do therapeutically.
Is it fair to say that the way the Ferreters handled this situation probably exacerbated these behavioral issues?
Yes.
But were those behaviors that had caused by the Ferreters, in your opinion?
No, I don't believe so.
I'll get into the specifics of that in a minute. Does the fact that Tim Ferreter handled the situation as inappropriately as he did, does that change any of the opinions that you've come to in this case?
No.
Why not?
Well, I mean, I think that what we see as a child early on that had a lot of difficulty with internal controls. Most children by the age of 5, if you want to kind of push it to 6, have already learned how to control themselves. They can control their behaviors. They don't tantrum. They can control, if they feel like they want to do something, they can control impulses. But I did see through the records that this was a child that had no internal controls. And lots of times when a parent has a child that has no internal controls, they do try to put external controls around that child. This, of course, was beyond the pale, but those external controls are not something that is an unusual thing for a parent to do if they feel like the child is a danger to themselves, others, or is doing something so impulsively, and they need to keep an eye on them.
Okay. I want for the jury to establish sort of the timeline that I think is relevant in this case. So I'm going to state this testimony and let me know if it's correct. And this is the testimony from the trial that you reviewed.
Roach.
You're not getting cashews. I know no matter how much you come over here and try to worm your way, you're not getting cashews. Cashews are people food. You are not getting people food. I am very sorry. No biting. Okay. It's holy water time. We do not want to bite. I do like this expert as opposed to the other expert. I kind of feel like she's been in the trenches a lot more. Just conversationally, I seem to just person to person, I think I would relate to her better than I would the other expert. And that's just on a personal level, nothing against the other expert. I just feel like personally, I think she's much more personable, but that's me. I think the other expert was a bit paternalistic, but as I said, that's more of a me opinion. We might be going to maybe halfway or finish with the state's, or the defense's direct, and then come back tomorrow with the cross.
All right, the objection is sustained. Ms. Murad, you can rephrase the question. Thank you.
Because Fry is getting tired of being inside, all the insides.
So I want to go through some of the underlying facts.
And we'll
that
come
you
back in the
relied on and come into
afternoon
your
with
opinion,
this.
Okay.
Yes.
And specifically about when locks were placed on one store. Okay. So is it your
not-
understanding, or were you assuming this when coming to your opinion, that this was born on February 28th of 2019?
Yes.
And that a room in the garage in Arizona was made about a week prior to that?
Yes.
And that a lock was placed on a room inside the home in Arizona that lived in while Tracy was pregnant?
Yes.
Given that it was born in late February, is it fair to say that that has to be between about May 2018 and February 2019 at some point?
Yes.
Okay. I want to start by talking about some of the facts that Wade Myers relied on in his testimony. You already stated that you reviewed his trial testimony and his deposition, correct?
Yes.
Wade Myers testified that he did not have any substantial behavioral issues before the age of 8 or 9. Without getting into any specifics, is that a true fact based on your review of the records?
Sustained.
Judge, can we approach on this?
You can.
If this particular lawyer felt that the other witness, the other expert, needed to be interrogated better, she should have done the interrogation. She should have done the cross, because I feel like Cousin Lemmy did a terrible job. And I know that the banner on the bottom is wrong, but she didn't spell her name out. So I'm not going to put her last
Right, the
name
objection is sustained
wrong.
without prejudice, Ms. Murad, for you to rephrase.
Without getting into specific acts, have you reviewed evidence that shows that there were in fact behavioral issues prior?
Sorry, I need you to approach again.
Yeah, and I like this therapist, but it also ticks me off that, and okay, I don't know Florida geography, so I don't know how far Fort Lauderdale is from Tampa, but you're telling me that there's a psychologist that kind of works with uh, parents that are dealing with almost exactly what they were dealing with, and I'm guessing Dr. Google, and has a private practice. It 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 just seems like they found something that wasn't working, but they didn't. Again, the way the defense is put up, it doesn't really show the lengths they went to get extra help for him. It just shows, oh, well, we took him to a pediatrician and a couple therapists. I mean, if it showed their Google searches, if it showed, they went to X, Y, and Z doctor, that they, were looking for, were put on a wait list for this program and a wait list for that program. And, the local police, recommended this, outreach program for the first time he ran away, that would have been more compelling to me than, oh, well, this therapist that specializes in who you should have been seeing says this. But I am not a lawyer. So who knows? John Mayer is coming to Indianapolis. A must miss. Ugh.
Ms. Murad, you may continue.
Thank you. Did you rely on records that showed and had behavioral issues prior to the age of 8 and 9 in coming to your various opinions in this case?
Yes.
Did you also rely on records that showed them did in fact have school suspensions?
Yes.
Would you characterize the time that was spent in his room? Would you characterize that as him having experienced solitary confinement for 3 consecutive years?
Not really, in terms of, you think about 3 full years of somebody being in solitary confinement where they're having no stimulation, they're not getting out of their room, nothing is going on like that. So no, I saw videos where he was out of the room, where he was eating with the family, where he was in the cul-de-sac or playing with the dog out back. One, he was helping them clean up the yard. One, he was helping them all move in the house. One, he and Tim were sitting at a table having lunch together. Videos where he's watching football with the family. So no, I didn't see it as, he was locked in a room at the minute he gets home, and then he's never let out of that room until school time.
Were those videos that you reviewed Ring camera videos from the time period in Jupiter?
Yes.
Did you also review videos of him participating in meals with the family?
Yes.
Is there any evidence in the record that was only provided leftovers to eat?
Sustained.
Did you rely on any evidence in the record that showed that it was only given leftovers to eat?
Overruled as to that question. You can answer, ma'am.
No, I did not see in records where he was only given
okay.
leftovers to eat.
Okay, I want to get into your sort of specific opinions at this point. Do you have an opinion as to whether or not it has a lack of inhibition and emotional regulation?
Yes.
What is your opinion as to that issue?
I believe that struggles and has clinically significant signs of lack of inhibition and emotional regulation.
What did you rely on in coming to that opinion?
Well, there were a number of things, but one thing in particular is he had a neuropsych done in 2022. And so that report was very helpful to me in determining how his brain was functioning.
You said neuropsych. What is that?
Neuropsychological testing is a psychologist that focuses on that focuses on the brain, and the testing then shows skills and abilities that the brain is able to do.
Is neuropsychological testing something that you routinely review in your practice?
Yes.
And is that both your clinical and forensic practice?
Yes.
Do you personally administer some neuropsychological tests or the tests that were administered in this case?
Sure. The vast majority of tests that were administered in that case that the neuropsychologist did, I give.
Okay. So can you take us through what the different parts of a neuropsychological test are? And I have it in front of me, should you require your recollection to be refreshed. Would that help?
I have it too. So a neuropsychological is very similar to a psychological evaluation. The difference is that they focus more on brain functioning. So they're looking at, how what are their skills, their abilities, and how their brain is functioning.
Thank you, Crime Spies.
In this particular case, the doctor did get background information. I believe he spoke with mom. He also had records that he reviewed. He gave neuropsych testing. He gave quite a bit of neuropsych testing, scored that testing. And then he did what we call a mental status exam, meaning you have the patient in front of you and you're actually asking them questions, seeing how they reason, seeing if they are logical and relevant, watching their behavior, watching their mood and their affect, and you're trying to determine, where they are at that moment in time in terms of their psychological stability. So he also had that as part of his evaluation. And then he wrote up a report telling all the information that he got from the testing, from the interviews, from everything.
You stated that the neuropsychological testing includes information from mom. Is there, how do you determine if that's biased or not?
Well, I mean, you're going to have to get information from caretakers. That's just part of what we have to do to get full information. You can absolutely look at the information that you're given and you can see, do records back that up? Is there anything that backs up what I'm being told? When you're giving testing to a parent or a child, that testing has validity scales. So you can tell through that testing if a parent's totally very negative toward a child, overly positive, thinking their kids have, halo and wings. You can tell these things in the testing. So that kind of gives you an idea of if someone's being truthful or not. And the same with the patients, the same with the person that you're interviewing.
What did the validity testing in this neuropsychological evaluation reveal about Tracy Ferreter's responses regarding?
Let me have your approach.
Yes, sir. Yes. You weren't supposed to get this big. I was supposed to not have to move things back on counters and have to protect the table and plates. You were not supposed to get this big, Scrappy Doo. Okay, so how far was Jupiter from Fort Lauderdale then? Because she's saying that she deals with, with a lot of sort of the behavioral issues and parents and stuff that kind of right the alley that they would have had to be dealing with. She's in private practice, and I'm wondering if the family did any sort of research.
Based on your review of the neuropsychological testing, do you have any concerns about the validity of that testing?
No.
What in the neuropsychological testing has informed your opinion?
Yeah,
There
We're
were a couple of
learning
things
that.
that stood out to me. He did an IQ test. He did an achievement test. The doctor did an IQ test also did an achievement test. Those things were pretty standard. He also gave him what is called the brief, which is a test that looks at executive functioning, meaning frontal lobe of the brain, pretty much. How is someone functioning in terms of their brain and their behaviors? That testing was interesting to me. On that test, scored within the clinically significant range. When we say clinically significant, meaning it's above what somebody would just normally be. So it's clinically significant, and it's something that is going to be kind of
Possibly.
on our radar. So on the inhibit scale, he scored clinically elevated, meaning that it's very hard for him to be in control of himself, especially with peers in the classroom. He requires a lot of adult supervision. His self-monitor scale was also clinically elevated, meaning it's very hard for him to understand the effect that his behavior has on others. He doesn't really have any insight into how he presents to others and what he's doing to others with his behavior. He also had a clinically elevated score for emotional control, meaning when he is flooded with emotion, he can't moderate that. He is explosive with his emotion, whether it's rage or screaming or breaking things, whatever.
Okay.
It's very hard for him to manage emotions, and especially anger. And just his regular emotional regulation index was very high. And, this is important to me, and it informs my opinion because we see when children have been traumatized, and normally very early childhood trauma will create a child that has huge problems with inhibition, emotional control, and they are completely unaware that, everything that's going on around them is because of them.
You mentioned just now that this is about sort of what happens in early childhood. You also mentioned that these are tests of executive functioning. So let's start with this. When is executive functioning developed in a person?
Thank
Well,
you.
executive functioning is ongoing, right? So the brain is continuing to grow, and the brain might continue to grow into adulthood until the 20s or in the 30s in some case. So so that's a dynamic process. When we see things like in this testing, normally we can relate it back to children in early childhood, because it's early childhood where we learn to manage our emotions, to not act out, to kind of be aware of how we are and what our peers think about us. And so that's a pivotal point where that part of the brain can be damaged, and then we can start to see testing like this.
Is it your opinion that the results that we had come from early childhood neglect?
I'm sorry, say that one more time.
Sure. The results that we're seeing on the neuropsychological test, is it your opinion that those resulted from early childhood neglect?
Yes, that is my opinion.
Why is that your opinion?
I feel like that the early childhood neglect
Hello,
that we
Stray.
see in him from, being in a foreign orphanage, and from the records that I reviewed from that orphanage show, not only did he have severe neglect and it was malnourished, they were feeding the children sugar water in one of the records, and there was a very high infant to caretaker ratio, so that caretakers can't take care of all these babies that are in the orphanage, so they didn't get their needs met. He also had scabies on his body that were not treated medically. So this is a child that was severely neglected. We have no idea what happened to him the first 7 months of life before he was put on the orphanage door. We have no idea the neglect or the abuse. But I think that when you see that type of neglect, there is definite brain reaction from that. There's no way that you can have a child that is being neglected. And really, if you think about being ignored or the scabies, like even medically neglected and abused, that would not have some kind of brain fallout because of that.
To state the obvious, is that prior to the Ferreters adopting him?
Yes.
When was this neuropsychological test conducted? If you have it on there.
I will look. October of 2022.
Is the fact that if it was after January 28th, 2022, change your opinion about the fact that this has to do with early childhood neglect for him?
No.
Why not?
I mean, I feel like if this testing had been done, even 2 years before, we probably would have seen a very, very similar pattern. We probably would have even seen a similar pattern when he was younger, because we can tell through the records that this is impulse control, self-monitoring, emotional regulation. These were things he consistently had problems with across all settings.
Is there any evidence in the records that any of the physicians or psychiatrists or social workers that the Ferreters went to recommended a neuropsychological evaluation?
No, I never saw that recommendation.
I now want to talk about another opinion in this case. Do you have any opinions about whether or not it has symptoms that are indicative of an attachment disorder?
Yes.
What's your opinion?
I do believe that his symptoms are indicative of an attachment disorder.
Why?
So In order, first of all, I see reactive attachment disorder was diagnosed in the records for him, starting as early as I believe he was 7 or 8.
Now, I do think
I don't
it's
know that
interesting because the other expert did kind of poo-poo the reactive attachment disorder because it was from a social worker, not an actual doctor. Um, not to not to poo-poo social workers because some of them do have actual doctorates, but I I must say again that I really do like this particular therapist. I just think I gel better with her. Again, nothing against the other expert. This one seems much more personable and approachable, and she's explaining things very well. I wish that the parents had gone to see her, you know, if we could, hindsight 2020 and they could have taken Ronan to her. I feel like that would have been the best of all possible options, but I do
I
like
know
her.
that at 7 or 8, they had fully diagnosed it, but the therapist was telling the parents, hey, I think this is more than what I thought it was. And I think I think it might be reactive attachment disorder. And then it was more formally diagnosed by a psychiatrist a couple of years after that. So I not only see it in the records, but also in terms of the behaviors that we were seeing and through the records, point to a child that's having problems with attachment and pretty significant behaviors because of.
Okay, guard doggo. Have you spazzed out enough, sir? It's just middle daughter. She was wearing a hat. Are we going to have to do photo lineups of people in hats and people not in hats? So you don't spaz out? Spazzo? McSpazzing it? You are fine. It is just a person in a hat. I believe he is in a group home right now. And I believe the other biological children are with family members, along with the. Okay, that's how you spell her name. She didn't spell her name when she came up, so I didn't know how to spell her name. But thank you. Normally they spell their names, and I can get it from when they're spelling it out. But she went right into questions, and I didn't want to rely on what the closed captioning says. So, look, I did Aussie man for the Australian person because, look, I had no idea. He went way too fast. But I didn't want to misspell her name, and rely on closed captioning, but I also didn't. Yeah. So, thank you, Ghostery. I did not know. We are still a duct tape and
So let
holy
me stop you
water
there because I want
production
to
round here.
understand what an attachment disorder is. So what's attachment?
Well, attachment is the most fundamental, basic thing that children need in order to be successful in life.
Thank
in
you.
order
Very
to
good.
Make friends,
Very much.
have intimate partners,
Okay.
being good at their job. Being
I
able
will
to
add
attach to
that.
people means that you have stability, you have empathy because you can understand what someone
Well,
else is feeling, not just yourself.
if I don't
It
catch
also
their
helps you
names,
establish
I
trust
will put my
so
own
that you can have a
headers on
relationship
there.
where you can be independent and someone can trust you and you can trust them that they're going to meet your needs if you need it. When children early on don't get that, there's a whole disruption that happens that affects every part of their life because we're social creatures. And if you're not able to trust people and navigate life socially, then there's a problem and it leads to what we call a disorder.
When is attachment developed in a person?
A lot of
My middle
attachment
teen
issues have been looked
daughter.
at, of course, in my field, because it is such an important issue, and a lot of things hinge on your ability to attach in a healthy way. Normally, what we see is there's a cycle of attachment from the moment that child is born. So what we see in the cycle is a child that is born, and let's say that child is wet or soiled or hungry or cold. That child starts crying. Immediately, an adult comes, a caretaker comes, picks up that child, takes care of that child, soothes that child.
Well, sorry, I was
child's
trying
then
to
able
close
self-regulate, go
down
back to
the
sleep or
thing,
whatever they
close
do.
down the
This
camera,
cycle
close
occurs
everything.
thousands of times with parents. If you've ever had a newborn, you know it's constant. And if you're constantly going after that newborn every time they cry, soothing that newborn, helping that newborn then learns, I have someone I can trust. I have someone I can attach
Fry
to.
is
and
about
I
4
know that
months
if I get
old.
out of control or I need something, there's an adult that's going to come along and that adult is going to help me. Children that do not get this, there's an interruption in that attachment. So you can imagine all the things. They don't trust that anyone will ever take care of them. They don't trust that their needs will be met. They can't see the world from anyone else's perspective. So attachment is a huge thing.
When we talk about attachment, I mean, what separates attachment disorder from a kid that's just like kind of awkward? Like, because it sounds like it's something that affects the personality, but is it just that you kind of end up being like uncomfortable or awkward, or are there other behaviors associated with having an attachment disorder?
When you have a disorder in general, so I'll talk in general first. When you have a disorder, a lot of people, you'll hear people say, oh my gosh, I've got bipolar, I'm so moody, or oh, that kid's got ADHD, he's so hyper. It's not just something that's at the level that we normally see in life. It's at a level that we think that it is clinically significant, and it's a disorder. It's disrupting their life. It's disrupting the lives of people around them. So just because the nature of the disorder means that this is something that's hugely problematic, not just to the person that has it, but to the other people that are around that person. And in terms of attachment disorder in particular, what we normally see. So normally you'll get a child that has reactive attachment disorder. They come out of a very bad environment. They go into a home that's loving and kind and has stability and structure. We normally see that the child begins to get better. So the attachment disorder gets better. There are children who have what we call persistent reactive attachment disorder, where the damage was so severe in childhood that as they get older, we don't necessarily see that damage start to go away. If they're plugged into the right therapies and they know the right places to go, and some of them, have to go to higher levels of care, then we might see some sort of healing, but it's something that they will struggle with, for some of these kids, for their life.
What behaviors are associated with reactive attachment disorder?
Overall,
Go ahead. What behaviors are associated with reactive attachment disorder?
So when you look at, when we diagnose, as psychologists, as psychiatrists, anyone in the mental health field, we have to use the Diagnostic and Statistical Manual. So this tells us what signs and symptoms to look for and how to diagnose. So if you're going to look up reactive attachment disorder in the DSM, you're going to just find pretty much a general way of looking at symptoms. So it will be that the child cannot be soothed by their caretaker. The caretaker tries when the child is out of control to soothe them, and the child wants none of it and continues to tantrum. Or the child doesn't go to that caretaker for the caretaker to take care of them. Most children, when they get hurt, run to their parent. No, these children do not. They kind of keep the parent away. So there's kind of a general way of describing reactive attachment disorder when you see it in your practice. However, when you start to look at when people are studying this issue, what you will see is that there are certain behaviors that are kind of indicative of a kid that has reactive attachment disorder. And it would include lying, frequent lying for no good reason, just lies that make no sense. It can be aggression, it can be violence, it can be being mean to animals, being mean to younger children, stealing, hoarding. Food is a big issue for children with reactive attachment disorder. So they gorge on food or they steal food. They're constantly food preoccupied. Some of them don't eat. So it really just depends on, how that is manifesting in each individual child. But it's a significant psychological disorder when you see the symptoms involved of children whose reactive attachment disorder did not get better just because they were put in a loving home.
What, in coming to your opinion that has behaviors indicative of attachment disorder, what are you relying on, or can you explain to us how you came to that opinion?
Yeah, so there's multiple records that talk about the behaviors that the family was seeing and dealing with in the home, from psychiatrists, from a treatment provider in 2015, all the way up. All the way up to now, we see these behaviors. So it was pretty well documented that the behaviors that were being seen were indicative of a reactive attachment disorder. The lying, the stealing, especially the food issues, just almost everything. Cruelty to animals or being mean to animals. I'm not going to say cruel like horrible, but being mean to animals, being mean to younger, more vulnerable children. These types of things we do see in his history.
And does that predate, let's say, about May of 2018?
The very first record I saw where the family was really describing the behaviors that they were dealing with was 2015. So I believe he was 7 or 8 at that time.
You talked a little bit about gorging
Yes.
being common for
teething.
children with attachment disorder. Can you
My
sort of take us
arm
through
looks a
what
bit like
happened and why that happened?
mincemeat. I'm
Well, I
hoping
mean,
that
I think it's easy to understand.
that'll be done
If you
soon.
are starving as an infant and nobody is feeding you, then your brain has learned that you can be hungry and you're not going to get taken care of. You're not going to get fed. So it becomes a preoccupation with food, a preoccupation on how do I get food, and when I do get food, I want to eat every single thing that I can eat immediately. Or I'm going to hoard food. I'm going to hide food in my room. I'm going to hide food in my backpack so that I'll always have food. It's really very sad because it really is from a brain that was so deprived of basic needs, and now even into childhood they're still struggling with that kind of stuff. And we see that with a lot of food centric ideas and wanting to get a hold of food, and not having any kind of breaks on food when he does get a hold of something sweet, to the point of even stealing food.
Is that sort of gorging of food and hoarding of food? I mean, is that healthy for a child? Should a parent allow that to continue to happen?
No, you wouldn't allow a child to gorge on food.
Is there any indication in the record that the Ferreters were educated by a psychiatrist or a medical professional about how to handle this gorging issue in a meaningful way?
So Stan, you can rephrase, Ms. Moran.
Sure. Do you have any opinion, and we'll talk about this more in detail, as to whether the Ferreters acted with malice?
Do I have an opinion? Yes.
Okay, what's that opinion?
I do not think that they were maliciously trying to harm their child and make things worse.
I want to talk about that in more detail in a little bit, but as it relates to the food, why do you think that?
Yes.
Well, I don't understand.
Sure. So I want to talk about your opinion regarding them not having malice and what they did, but as it relates to and how much he was permitted to eat, what is your opinion about that and the fact that they were not acting maliciously?
Oh, okay. So I think that not only in his deposition, but also in the deposition of his sister, they do talk about that the mother was very health conscious, that the mother didn't want the children having sugary snacks. They mentioned the snacks that she allowed them to have. And forgive me if I'm wrong, but it was stuff like granola and yogurt and bananas and things like that. The sister testified and her.
Sustained.
Without stating exactly what was said, can you just talk more generally about your opinion?
Sure.
Thank you.
Sure. So I believe that the mother was trying very hard to make sure that didn't get too much sugar.
Sustained.
What is your in determining? So I guess not speaking about your beliefs, but what the records actually show. What efforts were made by the Ferreters that makes you believe that it was not malicious?
Yeah, I think so. I feel like these parents went into this adoption knowing that their son had been not horribly, but deprived in early childhood. And I feel like you may have like a mental comprehension of that, but when it started to manifest in early childhood, maybe they didn't understand how big of an impact this was going to have. And I wish that this therapist had been in their life because, oh my goodness, I think that this would have had a great impact had they been willing to accept the help. And I don't know if that's part of the two-pronged problem, is that they weren't willing to accept outside help and they wanted to do it all by their own selves. Or again, I don't know that the defense focused on the right part, which is should have been a parent's journey to find how, help for their child instead of my child is a bad kid. I think the defense did their client a disservice making it about this kid is terrible versus we were and admittedly maybe they didn't. I mean, maybe they didn't have that story to sell. So it could be that they didn't have that particular, fact pattern to really sell. But, if they did have that fact pattern to sell, that would have been the story I would have gone with. And they might not. I mean, these people might just, they found, locking him in at night. That was their pattern. That's what they were going to stick with. You just get stuck in a pattern and it wasn't working, but they were there. And I don't know. This case is just incredibly sad
Overruled, but the
for
witnesses
all of them.
instructed not to relate what anyone said to you, just what you reviewed and what drives your opinion.
According to the records, A pediatrician told mom not to give.
Sustained.
Do you have any belief, is it your opinion that the Ferreters were withholding food from him intentionally to harm him?
No.
Is it your opinion that it is related to the fact that he was hoarding food as a result of his earlier condition?
Overruled as to that. You can answer, ma'am.
Go ahead. Yes. Okay. How are children with attachment perceived by adults who are not their parents?
Oh, that's a good question.
Can you restate that question again?
Sure. How are children with attachment perceived by adults who are not their parents?
Sustained.
Can we approach on this, Judge?
Can.
So thus far, everywhere I am looking, they have not released the transcripts yet of the Vandersloot hearing. Although Mr. Vandersloot said that he has given his life over to God or to Jesus, which, good for him, because
You may continue, Ms. Murad. The objection is sustained.
my favorite quote of all time, good thing Jesus loves you because everyone else thinks you're a dick.
Is reactive attachment disorder associated sometimes in children with a level of manipulation?
Approach.
I know it's probably frustrating for the witnesses and, everything else, but I really do like that both lawyers are fighting for all of this. I mean, again, both sides deserve a vigorous, defense. The state is fighting hard and the defense is fighting hard. So I'm of the opinion that steel sharpens steel. I would much rather both sides be fighting and bringing their game.
All right,
and
the
just not
objection is
wearing
overruled with
little
directions to
bow
counsel to
tie.
rephrase the question.
thing. 'Cause,
With reactive attachment disorder, is manipulation by the child who is diagnosed, is that common?
Yes.
Okay, can you explain that to us?
Yes. So these are children that want control over their environments. They don't trust adults. They are, looking for ways not only to seek attention, but also to manipulate, to get their needs met. They feel like they have to manipulate to get their needs met, and rather than being direct about it, because their needs were never met directly.
Is your opinion that one also exhibited these behaviors that are indicative of reactive attachment disorder?
Yes.
Explain that to us without getting into anything prior to his age of about 9 or 10.
Okay. Are you asking me what in
What behaviors
general
did
than
exhibit?
before 9 and 10?
Oh, no, I'm
Rappa,
sorry.
Dr. Rappa, can you pull the mic a little closer to you
sorry.
so you picked up better? All right, thank you.
No, I'm sorry. I'm asking you to talk about specific behaviors in the record that have led you to that opinion without getting into the specifics of anything prior to the age of 8 or 9.
Thank
Sorry,
you.
9 or 10.
Thank you for the clarification.
No problem.
Yes. So manipulation by Rome. He's a very interesting child. So at one point,
I'm going to sustain the objection. You can restate the question and we'll hear the answer again.
Is there, and on what basis, Your Honor?
I'm sorry?
On what basis is it sustained?
Her opinion as to whether he's interesting or not is not relevant to the case.
Okay, without saying that he's interesting, could you explain what behaviors you reviewed in the record that are helping inform your opinion?
okay. So in the record, there were
Overruled, you can state what you reviewed, ma'am, and how it informed your opinion, but you cannot go into detail about what specifically was said because that's hearsay. So you have to be able to answer the question posed by your attorney without disclosing specifically what was said by someone outside of this courtroom. Okay, thank you. You understand that instruction? All right, well, we'll see if you can follow it.
This poor
Go
witness
ahead.
is just like,
So what
I don't
records did you review that
understand anything.
School records, also records of when he would go to the doctor or saw the psychologist or psychiatrist.
Did you have an opportunity to review the video deposition of?
Yes.
And that was about 5 hours?
Yes.
Is there anything about the way in which it presents that also is indicative of attachment disorder?
I mean, I don't know that you would look at him and you would say that the way you present is, an attachment disorder. But the things that I noticed in the deposition or that were kind of flags for me as a psychologist, he is very kind of detached from what he talks about. He can talk about it in an intellectual way, but he doesn't necessarily talk about it in an emotional way. So he kind of gives you facts.
I also noticed
without
that.
necessarily having that emotional congruence with the facts. One of the things that is interesting to me is that during the deposition, he was pretty blunt affect. He doesn't have a whole lot of affect on his face, whether it's, joy or anger or anything, it's kind of blunted. However, during times where he would talk about things that he had done, such as giving beer to his younger brother and to see the effects of alcohol on young children, he started giggling, or he would laugh when he would talk about that he went into his sister's classroom.
Overruled. You can only say what his observations were and his response, but not what he said specifically. So overruled.
Go ahead, Dr. Rapid.
So he would laugh at inappropriate things that he had done. But other than that type of laughter, he was pretty blunted in terms of his affect.
Why? I think you called it congruence. What do you mean by congruence?
It's really important when we're communicating with people that we are congruent. So what we're feeling is what we're showing to that person. If you're feeling something and not necessarily showing it, then people can kind of pick up that you're incongruent, something is going on with you, and it leads to lack of trust. So it's important. Congruence is important. It's also important because it makes somebody predictable, so that if you say something to me and I know that you are someone who what you say is exactly what you feel, then I can trust you and I can predict your behavior towards me. When people are not congruent, you can't necessarily predict their behavior toward you because what they're saying and what they're actually feeling are two different things. So the congruence is a huge issue in relationships.
Why is that concerning for children in particular?
And
that lack of congruence.
A lack of congruence in children. One of the things that an adult role is to teach children to be congruent, to teach children what you're feeling is what you need to be speaking, in a respectful way, but you need to speak your feelings. If they don't have that, then the child is an unpredictable child because the child can parrot back to you what they know you want to hear, but they're not necessarily changing anything internally.
What is the treatment for an attachment disorder? What are the treatments?
There are treatments for attachment disorder. There are also some treatments for attachment disorder that are very, off the cuff and not good treatments, and nobody really and professionals would recommend them. But the treatment right now for attachment disorder, most people would treat it as a trauma-based disorder, and they would do trauma-focused cognitive behavioral therapy or regular cognitive behavioral therapy. There's dialectical therapy. There's certain therapies that are known to work with children that have attachment issues.
Were any of those ever recommended to the Ferreters?
Sustained.
Is it your opinion that the Ferreters were, do you have an opinion as to whether the Ferreters acted with malice when it comes to the treatment of attachment disorder?
Yes.
Okay, what does that
Madam
mean?
Mara, can you approach for a second?
Probably going to go for another 20 minutes, and then I'm going to call this a good section. I might do the closing arguments, depending on how much longer, because didn't she say they had 3 hours of video? Sorry, I'm trying to see how long. Okay. We'll probably finish this up on Friday. I'll probably go another 20 minutes and we'll finish this up on Friday. Just because, unfortunately, I have laundry to do. Don't get too excited. My glamorous life. I know.
Right, so the court is reconsidering its prior ruling on the question of whether there were any recommended treatments. Ms. Murad, you can ask the witness that question with respect to her review of the records that she had presented to her in this matter. But ma'am, just so you know, you're only able to answer that question with respect to the record.
And I do have a question for you guys. There is a case that is, we will be behind in this, but it is a fairly controversial case, and I don't know if you guys want me to cover it. I believe it's fairly new, so we'd be a little bit behind. I can cover it, some of it this weekend, depending on if we want to do it. I believe it is, oh gosh, Potentially Criminal was covering it. And it was one I wanted to look up. Now I can't remember what it is. Let me look it up right now as I am talking. It depends on if you'd like to watch it. It will be a bit, like I said, it would be a bit controversial. It's the murder case with Ethan Liming. So I don't know if you want to get in on that one. It's, like I said, it's a bit controversial. It's going to be all the spicy. It's going to have, is this self-defense? Is this not self-defense? Did this, young boy, being a ignorant jackbutt, deserve this? Did he not deserve this? When did this become a fight? When did this become a beatdown? All of this, it's going to have potentially racial elements to it. So I don't know if I was going to touch that one, but it is a case that is going on. And then remember, tomorrow, Thursday, I will do morning newsy news. Actually, I'll probably just stop here for today. I have let's see here. Let me get the timestamp, even though I generally don't just keep these up. So I've got the timestamp here, and we know where we are. But tomorrow, the plan is I will do newsy news. I am going to take oldest son out to the mall because he got AB honor roll. And then tomorrow afternoon, I will haul butt to get the boys, but there is supposed to be the Delphi hearing, and it is supposed to be televised. So what I plan to do is we will be, as always, behind, but I will be covering that at Mo time. At Mo speed, at Mo time with Fry. And so I will stop here for today. We've done about a good 3 hours of this testimony. And, like I said, I really wish, I don't know, I feel a tragic sense of almost a bittersweet what could have been had this child gotten to meet this particular doctor and really work with this family. I am good on my watch hours. So thank you guys. It is a bittersweet wish that this family had gotten help from this doctor before it all went to crud. You can absolutely, if you want to. I am going to start, I think, my goal next week is to maybe start chopping up mornings with Mo to, if people don't have an hour, to just have those come out as short little clips that I can send out as shorts or something. I don't know. I'm thinking about things, and I'm going to see if my technical prowess can do them. But I'm trying to think of things. I am going to have probably next week, I am going to add probably a noon kick show with spicier news show or news things that, you know, are a little too spicy for YouTube, but will probably go over there. I am just trying to expand and not nuke my channel. And still maintain hydration and, you know, sanity and all the other things. So thank you guys for being supportive and for believing in me when I didn't believe in me, because I would have never thought I would have be doing this. And Friberto, what is going on here? What is this? Oh, for the love of Cheetos. He has a ding dong. Oh, well. Well, thank you guys. You know, thank you so much. You have no idea. Mr. Mo has been my biggest cheerleader since I started, and I appreciate you guys being there too. And now I'm starting to believe it too. And Friberto has got to go out though. We have to take a walk. He cannot sleep all day because he will have zoomies all night. And then my arm looks like chopped liver, and Mr. Mo is not too happy about that. All right, guys, I will see you for nightly newsy news, and then we will get things started with that. So I will see you guys in a little bit for nightly newsy news. Have a wonderful rest of your day. Yes, hydration, white or red or cider. I will be picking up ciders. We will be up in Greenwood. It is going to happen. I am putting it into the universe or whatever people tell you on the secret or whatever it is you're supposed to do. I don't know. Something with crystals and blah, blah, blah. All right. I will see you guys later. Bye, guys.